So we're on the record in docket 22-02336, People of the State of Michigan versus Connor E. Long. Will the parties please introduce themselves for the record?
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
Erin Robinson, Assistant Public Defender on behalf of Mr. Long.
And this is the time set for a preliminary examination today. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant wishes to avail himself to a felony plea in district court.
Is that your understanding, Ms. Robinson?
It is, Your Honor. Thank you.
What's the nature of the plea agreement?
Thank you, Your Honor. The people have filed an information with the court. The defendant will be pleading as charged to count 1 listed on the felony controlled substance, possession of methamphetamine ecstasy. There's a Killebrew agreement that the defendant will serve 365 days jail, concurrent with his current sentence that he is serving in MDOC. Upon successful plea and sentence, the people would move to dismiss count 2 on the felony controlled substance, possession of fentanyl.
So it's Killebrew to 365 days to run concurrent.
That is correct, Your Honor.
With do you know what it's running concurrent with, what file that is?
It's an Isabella County case,
Okay.
But he's already in MDOC for that. So
It's in Isabella County.
Mhm.
And count 2 will be dismissed in circuit court.
That is correct, Your Honor. Yes.
And Ms. Robinson, is that your understanding of the plea agreement?
It is, Your Honor.
All right. May I inquire of your client of his plea rights and his advice of rights?
Yes, you may.
All right. Sir, you are Connor Long?
Yes, Your Honor.
All right. And you understand that the maximum possible sentence in each of these, there's 2 counts here. There's a controlled substance possession of methamphetamine ecstasy, which is a 10-year felony and/or $15,000. And there's a count 2 of possession of cocaine, which is less than 25 grams, which is a 4-year felony and/or $25,000. You understand the maximum penalty concerning both these counts?
Yes, Your Honor.
All right. If a plea is accepted in these cases, in these files, especially the count 1, which is the subject of this matter, you will be giving up the following rights at trial. Do you understand that, sir?
Yes, Your Honor.
I'm going to walk you through those rights. All right. Okay. If the plea is accepted, you will not have a trial of any kind. So you give up the right that you would have at trial if you did not plead guilty. Do you understand that?
Yes, Your Honor.
Okay. And you'd be giving up the right to be tried by jury, the right to be presumed innocent until proven guilty, the right to have a prosecutor prove beyond a reasonable doubt that you are guilty, the right to have witnesses against you appear at trial. Do you understand that?
Yes, Your Honor.
You, of course, have the right to counsel, and you are represented by public defender Erin Robinson. She would contest any charges and cross-examine any witnesses that would be brought against you. Do you understand that?
Yes, Your Honor.
Okay. You'd have the right to question those witnesses that are brought against you. You'd have the right to have the court order any witnesses in your defense. You'd have the right to remain silent during the trial, not to have that silence used against you, and you have the right to testify at trial if you choose to testify. Do you understand that, sir?
Yes, Your Honor.
If the plea is accepted, you'll be giving up any claim that the plea was a result of any promises or threats that were not disclosed to the court at the plea proceedings, or that it was not your choice to enter the plea. Do you understand that?
Yes, Your Honor.
We've talked about the plea agreement. You've heard the lawyers talk about it. It's a plea to count 1, dismiss count 2 in circuit court, and then there'll be a Killebrew agreement of 365 days to run concurrent with your Isabella County charge. Do you understand that?
Yes, Your Honor.
All right. If your plea is accepted, you may be giving up the right to appeal any issues from the trial because you won't have a trial. So you'll be pleading guilty because you are guilty. You won't have the right to appeal anything that happens at trial because there won't be a trial. Do you understand that?
Yes, Your Honor.
Okay. We've talked about the plea agreement. Counsel has talked about the plea agreement. Has anyone threatened you, or has anyone threatened you or promised you anything other than the plea agreement in order to plead guilty?
No, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth
Yes, Your
under
Honor.
penalty of perjury?
Yeah.
All right. I'll bring your attention back to April 25th, 2022 at the offense location of 2765 Eaton Rapids Road, that's Lansing Township, Ingham County. Is that correct?
Your Honor, and my apologies to the court, perhaps I missed it, but I believe that in order to take the felony plea in district court, Mr. Long must first enter a waiver of his
Sure.
right to the preliminary examination. And so I just want to ensure that we have done that step procedurally before, so that the
You're right.
court has the jurisdiction to take this.
You're
plea.
right. You're right. So keep all those rights in mind and let's make sure you waive your right to a preliminary examination. Lansing Township is the correct.
This is a Lansing Township venue, yes, Your Honor,
All right.
2765 Eaton Rapids Road,
All right.
Lansing Township.
So let's waive your right to the prelim and then we'll continue on with your plea agreement with your offer, with your advice of rights, okay? You understand you have the right to preliminary examination in this court concerning these charges today.
Yes, Your Honor.
And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that crime has been committed and the identity of the person who committed that crime. Do you understand that?
Yes, Your Honor.
All right, and the prosecutor also has a right to a preliminary examination within 21 days also, or a preliminary examination in district court. Do you understand that?
Yes, Your Honor.
If you waive today your right to a preliminary examination, you'd be waiving the right to have the preliminary examination in district court. We'd be moving right to the felony guilty plea in this court. But you do have the choice to contest the charges and cross-examine any witnesses. Ms. Robinson would be here for that. It's my understanding you're waiving your right to a preliminary examination today.
Yes, Your Honor.
All right,
The people would also unconditionally waive their right to the preliminary examination, Your Honor. Thank you.
thank you. I find the waiver to be freely, understandingly, and voluntarily made. We've already spoken about the plea agreement. Any questions, Ms. Robinson, about the waiver?
No, Your Honor.
Okay. Any questions, Ms. Housefield?
No, Your Honor, thank you.
Okay. All right, so I find the waiver to be knowing, voluntarily, and understandingly made, and so this case is now going straight to plea, and we've already started that plea, all right? So with the understanding of your advice of rights of plea and the negotiations that have continued and concerning that we've talked about, I'm gonna bring your attention back, and you're already sworn for the record, bring your attention back to April 25th of 2022 at the offense location of 2765 Eaton Rapids Roads, Lansing Township, Ingham County, state of Michigan. Were you at the Eaton Rapids Roads address on April 25th, 2022?
Yes, Your Honor.
All right. And it did in count one. Why don't you tell me what makes you guilty of the count one charge, which is possession of methamphetamine? Is that correct?
That is correct, Your Honor. If I may, just for purposes of the record, do a formal reading of the information.
Sure.
Thank you. And if the court may inquire, does the defense waive the reading of count two?
We do.
Thank you, Your Honor. The people of the state of Michigan versus Connor Elric Long in the, and I'm sorry, I don't have the, I'm sorry, yes, in the circuit court number 22-835 FH, is it? I'm sorry, it is. Okay, thank you. I didn't write that
Is it?
down. Thank you, Your Honor. So the people of the state of Michigan versus Connor Elric Long in circuit court file number 22-835 SH, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about 4/25/22 at 2765 Eaton Rapids Road, Lansing Township, Ingham County, the defendant did in count one, controlled substance possession of methamphetamine/ecstasy, knowingly or intentionally possess methamphetamine contrary to Michigan law. That is a felony punishable by 10 years and or $15,000. Court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest and against the peace and dignity of the state of Michigan.
Do you understand the nature of the charges that are alleged against you in this felony information?
Yes, Your Honor.
All right. And it's your intent today to plead guilty concerning your rights that we've already indicated to count one. Is that your intent?
Yes, Your Honor.
All right. And all the rights that I previously spoken of apply to count one. You plead guilty because you are guilty.
Yes, Your Honor.
All right. Now I will bring your attention back after being sworn in to April 25th, 2022 at 2765 Eaton Rapids Road, Lansing Township, Ingham County, state of Michigan. Were you at that address on that date?
Yes, Your Honor.
And in count one, tell me about what happened in order to set a factual basis for your possession of methamphetamine.
My girlfriend got pulled over and I walked across the street and police officers seen me walk across the street and stopped me and I had meth in my pocket.
Okay, and you knew it was methamphetamine
Yes,
in your
sir.
pocket? So you were knowing possession of methamphetamine at the time?
Yes, sir.
Any from the people concerning the factual basis for count one?
No, Your Honor, thank you. The people are satisfied.
Anything, Ms. Robbins?
No, Your Honor, thank you.
All right, I find the plea to count one to be knowing, voluntarily, and accurately made as a factual basis. So I will enter a plea to count one. Upon successful plea and sentence of count two will be dismissed. I've written the Killebrew agreement in the file. I'm assuming bond is to stay the same because you're accumulating credit.
The people have no objection.
All right. Anything else for the record in docket? This is now a circuit court 22023. I'm sorry, 220000835.
I
Ms.
know, Your Honor,
Housfield.
the people believe that the court has complied with the court rules in taking the plea. Thank you.
Anything else, Ms. Robinson?
No, Your Honor, thank you.
All right. Mr. Long, that's it. Your next dates will be in circuit court. So keep in contact. Your time is done here in district court. Keep in contact with your public defender, Erin Robinson, and she'll set the next date in circuit court.
Thank you, Your Honor.
Thank you, Ms. Housfield. It's okay. Does he need to sign this, the waiver and all that?
I know.
I'm assuming. And I signed the circuit court guilty plea. You want to look at that?
Yeah, if I can get it.
All right. Just in case there's something he needs to sign. Thank you, Aaron.
I'm here.
Let me see that.
Yeah,
I'm on.
I dropped it. Okay, I'll find it. I got it presented.
There we go.
Karen?
I need to do some magic stuff later.
Okay.
Yeah, I have a confidence. I've got two here.
So he's got to sign one thing real quick. Judge, can you grab a pen?
You sure can.
And work in this program.
I can go find Mr. Whiskey. Thank you.
There you go. Now we're all set.
Thank you.
Thank you,
Aaron.
Judge. And Wendy, Johnson was taken off the docket today, right? Because he been planted.
I found Mr. Whiskey. Thank you. Sanders?
Johnson? She just said Johnson was off the docket.
Why is he off the docket?
What did you think was
It's
off
a
the
Mr.
docket?
Abbott case.
Johnson, Ishmael?
Oh,
Oh, yes,
Ishmael.
he has the warrant.
Yeah, yeah. I just wanted to make sure. I didn't know.
I'm sorry, Ms.
Two
Robinson.
Johnsons.
For that.
Order for, you know,
Nathaniel, I'll put you in this lab. I gotta do a bunch of sending things to places.
Mr. Whiskey, we're ready on Sanders.
correct, Your Honor.
So we're on the record in docket 22-02722. People of the state of Michigan versus Camonte Sanders. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Sean McDermott, P46101 on behalf of the attorney of record, Steve Mamet, with Mr. Sanders standing to my right.
And sir, you are Camonte Sanders?
Yes, sir.
All right. Mr. Wisty, this is the time set for preliminary examination today. How are we proceeding?
Your Honor, it's my understanding defendant will be waiving up to circuit court. People will also waive their right to a prelim. Both waivers are unconditional. There is an offer that has been made, which would include the count one, carrying a concealed weapon. In exchange for that, the people would dismiss count two, and there would be an agreement to sentencing pursuant to the Homes Youthful Training Act.
That's correct, Judge.
Is that a Kilabruto HYTA or it's just a?
Killebrew.
All right, counsel may inquire of your client.
Certainly, Judge.
Thank you. You understand you have the right to a preliminary examination in this file in district court. Preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, sir.
You, of course, would be represented, you're represented by Mr. McDermott today. You'd have Mr. Mamet present, and they would contest any charges, cross-examine any witnesses in order to contest charges brought against you from the people. Do you understand that?
Yes, sir.
It's my understanding that you wish to waive your right to preliminary examination and have negotiations continue into circuit court, which would be the trial court. Your time in district court would be done. Is that true, sir? All right. And it's my understanding also that there's a plea agreement that's been offered to plead to count one, dismiss count two. And there would be a Killebrew agreement of Homes Youthful Training status. Do you understand that? And is that your understanding in negotiations at this time?
Yes, sir.
All right. Is it your intent to waive your right to a preliminary examination in district court today?
Yes, sir.
All right, Mr. Wisty, does the people also waive the right to a preliminary examination?
Yes, Your Honor.
All right. And I find that the waiver of the preliminary examination to be freely, understandingly, and voluntarily made. We've spoken about the plea agreement. The prosecutor also waives their right. I'll accept the waiver and bind you over to circuit court. Please keep in contact with your attorney, Mr. Mamet.
Yes.
Your attorney, Mr. Mamet, and he will provide you any future dates in circuit court that you need to meet, okay? Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. McDermott?
Just if I may inquire,
Sure.
do you have any objection for me standing in for Mr. Mamet today, Mr. Sanders?
Thank you.
Thank you,
All
Judge.
right. Standing, that's all for the record in 22-02722. Thank you.
Good day.
You too. And you can sign that. 22 02580, people of the state of Michigan versus Jason Williams. For the parties, please introduce themselves for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Williams, the gentleman who stands to my right.
And sir, you are Jason Williams?
Yes, Your Honor.
All right. Mr. Pfeiffer, this is the time set for preliminary examination. How are we proceeding today?
Your Honor, we are prepared to proceed with an examination today.
All
There
right.
was an offer that was conveyed to the defendant, and I'd just like to put that offer on the record.
All
It was
right.
my understanding that he has rejected that offer. The defendant is charged with count of home invasion of the first degree, larceny in a building, and domestic violence second offense. The offer was the defendant plead guilty to the larceny in a building and the domestic violence second offense. In exchange, people dismissed count one, the 20-year home invasion first degree. The defendant has rejected that offer, and therefore the people are prepared to proceed with the examination today with the testimony of the victim, Alicia Williams.
Mr. Palmer, is that your understanding, just for the record, of the offer that was refused?
That is my understanding, if I may inquire of my client. Your Honor.
Sure.
Mr. Williams, you and I have spoken about the plea offer that you heard the prosecutor state. Is that right?
Yes, sir.
And you and I have talked about that offer, at least. Is that right?
Yes, sir.
And it's your decision to reject that plea offer and continue with the preliminary examination this morning. Is that correct?
Hallelujah. Amen.
Thank you, Your Honor.
All right. Are there any preliminary matters to come to the court's attention before we start the preliminary examination? Mr.
Not for the
Pfeiffer,
people at this time. Your
anything,
Honor.
Mr. Palmer?
I don't believe so, Your Honor. I would normally ask for sequestration of witnesses, but it's my understanding it's just a one witness exam.
Okay.
So nothing further, Your Honor. Thank you.
All right. Mr. Pfeiffer, you may call your first witness.
Thank you, Your Honor. The people call Alicia Williams.
All right, ma'am, I'm gonna have you stand right up here. I'm gonna have you state your first name and spell your last name for the record.
Alicia Williams, Williams.
And raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
Yes, sir.
All right, go ahead and have a seat here, and I'd ask you to project for recording purposes.
Thank you.
Mr. Pfeiffer, you may proceed.
Thank you. Good morning, Miss Williams.
Good morning, Mr. Parker.
Miss Williams, do you know a Jason Williams?
Yes, sir.
How do you know a Jason Williams?
He is my mother's neighbor. Been for about 20 years.
And at some point, did you have a dating relationship with Mr. Williams?
Yeah, we were dating. Yes, sir.
Be able to recognize him again if you saw him?
Yes, sir.
And do you see him in the courtroom here today?
Yes, sir.
Could you please point out where he's located, maybe something about him that differentiates him from the other people nearby?
Yes, he has a black suit on with something cut around his head.
Thank you. If the record reflect that she has identified the defendant in this matter?
Any objection, Mr. Palmer?
Not for purposes of exam today.
And the record reflect the witnesses identified the defendant.
Thank you. Now, Alicia, back on July 22nd, 2021,
Mhm.
where were you living?
At my residence on 1217 Highland Street.
And is that in Lansing?
Yes, sir.
Is that in Ingham County?
Yes, sir. Yes.
Did Mr. Williams ever live there?
No, sir.
On that day, did he have permission from you to enter your residence?
No, sir.
Did he enter your residence on that day?
Yes, sir.
What can you tell me about what happened?
At night of July 21st, 2021. It was about 10, 11 at night. It was late. I was putting the kids to bed. I have 4 children. They all go to school. I was putting them to bed. 2 was up, 2 were up, 2 of my boys was up, 2 of my boys were still asleep.
How old are your children?
They are 11, 9, 7, and 6. So they're. Yes, sir. I was getting, it was a school night.
Okay.
I was getting them ready for bed. I recall 2 of them were asleep. 2 of them are still up.
And then at some point, did you hear something out of the ordinary?
I did, yes, sir.
What did you hear?
Something in my kitchen. It was the kitchen or my middle room downstairs, but I heard some commotion down there. And it was just supposed to be me and my 4 kids in the house.
So nobody else was in that residence? No one
sir.
else had your permission to be in that residence?
Correct. Correct, yes, sir.
Did you eventually find out what was causing the noise?
I did.
And what can you tell me about that?
I was hearing noise. I went downstairs to see what it was. And the defendant was in my kitchen lighting up a cigarette or black or something on my stove.
And how did this make you feel?
I was scared.
At this time, were you two still dating?
No, sir, we wasn't dating at this time. We have broken up already.
How recently did you broke up, roughly?
I want to say either May or April, but we had broken up in the spring, and this happened in the summer.
So only a few months before.
Yes, sir. Yes.
So what happened once you saw him in your home without permission?
Well, I went downstairs and I said, he's not supposed to be in here, da, 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 da. He said something, he was just lighting up the cigarette. I said, well, you're not, at this time, I already had the order protection.
You had a personal protection order?
I believe I had got it before that time. So he was not supposed to be in the house. Okay, long story short, I had ran upstairs. I told my kids to get in the room, close the door. 'Cause I
And
didn't.
why'd you do this? Were you worried for your children?
Yes.
What were you worried about?
He would either hurt me or.
And why was that a concern for you?
He's put his hands on me before. But this particular time, can I finish with the story?
Please, what happened when you saw him down there?
I ran upstairs. I was scared. I ran upstairs. I said, boys, get in the room, close the door. And about, it wasn't that long after, he had walked up my stairs, smoking the cigarette. And no smoking, but he had walked up the stairs. And I said, Jason, you gotta go. I said, you can't. Yeah, I did have the protection order. I said, Jason, you have to leave. I got a PPO on you. You can't be here. I said, I'm calling the police. He said, John said, I'm calling the police. You gotta get out because you're not even supposed to be nowhere around me.
We made it clear he wasn't welcome in your home, that you were calling the police.
Yes, sir.
What did he do in response to that?
He said he didn't care. He didn't give a F. Call those mother effers. I'm not going nowhere. So at that point, I said, okay. So at that point, I had grabbed my phone. It was a brand new iPhone, actually, the newest one. When I was dialing, my kids was looking, the two oldest that was up. I was dialing the number.
By looking, were they in the hall or were they just kind of peeking their heads
They were
out of their
peeking out.
rooms?
They were peeking out the door.
Okay.
As I was calling 911, he had grabbed my phone from me as I was calling, and we had a little scuffle. Over my phone. My kids was in the door. My hallway's right here. My room and the kids' room. So when he's grabbing my phone, we're scuffling. I throw the phone to my kids. I'm like,
For the record to reflect, she was indicating her children's room and her room were on opposite sides of the hallway.
yes, it was my hallways in the middle.
Yes.
Yes,
And
sir.
thank you. The record only reflects what's said, not what's shown. So I just
Yes,
want to make
sir.
sure it was clear for the
So
record.
just to,
course.
there was the witness made a motion indicating that the hallway was in the middle of the two rooms.
Yes, it is.
Thank you.
Yes, sir.
Thank you. And so you threw your phone into the children's room.
Yes, no, the kid, they was already out because we was
They were already
scuffling.
out of there.
Yeah, they already heard me scuffling. So I'm like, I'm throwing, I said, call 911, call 911. I'm trying to throw the phone. I don't know what happened, but he overpowered me and just grabbed the phone. And at this time,
So you said he overpowered you. He had his hands on you?
yes, sir, at the time I was pregnant at the time. when this happened.
Where, do you suffer any injuries as a result of this? Any scrapes, any bruises?
I lost the baby.
So sorry.
That's-
How far
That
along,
happens.
how far along were you?
I was 12, 13 weeks. I wasn't far along.
How soon after this did you realize that you lost the child?
About a week. I had to go to the doctor. I wasn't feeling good.
That was after this incident.
Oh, yeah, this was after. This is after.
So you said at some point you overpowered you.
Yes, sir.
What did he do after he overpowered you?
I remember him taking the phone. And I just remember screaming, and I know he had threw me down. And I landed on my stomach.
What happened after he got the phone?
He ran downstairs and he left. But this
And-
all went on for a good little while though.
And how long was it? Did you ever get that phone back?
When I got the phone back, it was already cut off. I already cut it off because it was expensive. I got it back around 2.5 weeks later.
And who'd you get it back?
I believe the defendant had gave it to somebody to give to me.
Okay.
Because at the time we couldn't be around each other because of protection order.
Okay.
Yes, sir.
Now, you said you were trying to get, well, he was trying to get your phone and there was a scuffle.
Yes, sir.
And the scuffle was violent?
Yeah.
At any point in it, did he make threats against you? That you can remember? And please, if I ask you something you can't remember,
Yes.
feel free to say I don't. It's okay.
Probably not at that altercation, but previous, yeah.
Previous.
Yes, sir.
I could have just one moment, Your Honor. Alicia, I want to talk a little bit more about your home.
Yes, sir.
So, do you frequently just leave your door wide open at night?
No, sir.
That night, was the door closed?
It was closed and locked.
And it was locked. I
I have an alarm system.
And now you have an alarm system. Do you know how he got into your residence or do you not know?
I had a key, a house key. He wasn't supposed to have my house key. He made a copy of my house keys.
But he did not have permission to enter your residence that
No,
day.
sir. I already had the PPO on it at this time.
Thank you.
You're welcome.
One last question. Did you
Yes, sir.
stay at your residence on Highland that night after the incident?
I had to go to my mother's house that night.
And
On a
why
school
was that?
night. I was scared to come back and I didn't have a phone. So I had to go tell my mom what happened.
And that's when you spoke with police?
That's when the police came. I had to wait till I get to my mom's house to call the police. So I didn't have a phone.
Thank you.
So I left to my mother's.
Your Honor,
Yes, sir.
at this time, people have no further questions for this witness. Thank you.
Cross-examination.
You're
Thank you,
welcome.
Good morning, man.
Good morning, how are you?
I'm doing well. How are you? So I have some questions I want to ask you. And just like Mr. Pfeiffer, if you don't know the answer to the questions I asked, that's completely fine. Just
Yes, sir.
let me know that you don't know the answer or don't recall.
Yes,
Okay, fair enough?
yes, sir.
So you indicated that, well, first of all, the evening of this incident, you made a statement to the police. Is that right?
Yes, sir.
All right. And when you made your statement to the police were in full uniform, correct?
Yes, sir.
Do you, if you recall, do you know if if they were wearing body cam? And if you don't know, that's okay.
No, sir. I don't.
All right. When you made your statement to the police, did you tell them everything?
Yes, sir.
All right. And you were truthful in your statement, is that right?
Yes, sir.
All right. As far as you know, you didn't admit anything, omit anything, leave anything out, anything like that. Is that right?
No, sir.
When you made your statement, did you ever tell them anything about having a personal protection order against Mr. Williams?
Yes, sir.
You did.
Yes,
All
sir.
right. So if you did tell them that, we would expect to see that either in their report or on the body camera. Is that right?
Yes, sir.
And when you made your statement, did you tell them anything about being pregnant at that time?
I believe I did.
You believe you did?
Yes,
All right.
sir. I'm sure, yeah, I did.
And
I was.
in terms of the injuries that you suffered that night, you only told them about a scratch, is that right? A scratch on your leg and a scratch on your arm?
They took pictures.
They took pictures.
Yes, sir.
All
I
right.
don't know where they're at now.
When did they take pictures?
The night, July 21st, 2021. The night I went to my mom's house after the incident.
When you say that they took pictures, how did they take pictures? Was it with like a cell phone or was it with a specific, like a regular, like, long camera with a big long lens on it?
It wasn't that one. It was like a cell phone.
It was like a cell
It wasn't
phone.
a long thing.
Do you happen to recall, there were, when the statement was made to the police officer, there was a couple of police officers there, is that right?
Yes, sir.
And there was a couple of male officers and a female
And
officer.
female. Yes, sir.
Do you recall whether it was the female or the male officers that took pictures?
No, sir.
All right. Do you recall them asking if you needed medical attention?
No, I don't recall that.
All right. You didn't go to the hospital that night,
Not
right?
that night, no, sir.
All right. All right. So I want to also ask you, you indicated that when the first part of this interaction on this night is that you were upstairs, you heard a commotion and you came downstairs. Is that right?
Yes, sir.
So your first confrontation with Mr. Williams on that evening was downstairs in the kitchen?
Not physical.
No, right. Yeah, let me clarify that. That's a fair point. The first time you interacted with Mr. Williams that evening was in the kitchen. Is
Yes,
that right?
sir. Yes.
And so there was some sort of a conversation downstairs in the kitchen before you went back upstairs to where your children were.
Correct.
All right.
Yes.
Any idea how long that interaction in the kitchen area lasted?
It had to be less than 3 minutes,
Less than 3 minutes?
less than 3 or 5. And it was real quick.
I got you. All right. So it was fair enough to say it was a brief conversation.
Yeah.
And then at that point, did you ask him to leave?
Yes, sir.
All
More
right.
than once.
And you then went back upstairs, is that right?
Yes, sir.
And it's my understanding that when you went back upstairs, he was still inside the house?
He was.
All right. Did you have an opportunity? Well, let me ask you this. In relation to this house,
Mhm.
did he enter through a front door, a back door, side door, or do you not know?
This was the back.
A
My
back
kitchen's
door.
in the back of the house.
Okay,
He's
so
in the back.
okay. So he comes through a back door. Did you see any signs of like that the door was forced in? For example, was the lock broken? Was the door wedge, or the door frame in any way splintered or broken, anything like that?
Not the back, but my front door was off. And I have that on camera.
The front door
My
was
front,
off.
the storm door, not the big door, like my storm door, that was pulled off the hinges. Yes, sir.
And did you ever report that to the police?
I believe I did. Yes, sir. Yes.
Before I forget, let me ask this. Did the police ever come back to your house to take any photographs of the house, of anything inside the house, anything like that?
Not the night of July 21st.
Okay.
This is a whole nother altercation.
All right. But that night, no one ever came to the house to take pictures regarding this incident we're here about talking about.
No, sir. No.
So you indicated that, well, and you didn't actually see Mr. Williams enter the house, is that right?
Correct.
Like, so you don't know whether he just opened the door, whether he used a key, whether he forced the door open. You're not sure because you didn't see him enter the house, right? You didn't?
Correct.
All right. And just to be, I realize I probably already asked you this, but just to be fair, by the time you encountered, he's already inside the house in the kitchen.
Yes, sir.
All right. So you head back upstairs, up the stairs and back to your children.
Yes,
Is that right?
Yes.
And your testimony is that Mr. Williams then followed you up the stairs?
I was already upstairs.
Or he came up, that's
Yeah,
fair.
I was already upstairs. That's what he.
Okay. And so the altercation between you and Mr. Williams that night occurs at the top of the stairs in the hallway?
Yes, sir, in the hallway.
All right. It never entered into any of the other bedrooms or anything like that up there? Is that right?
Well, when we scuffled, we was in the hallway in my room. We were right in between, but the end of the scuffle ended in the hallway.
Okay. And you had been in a dating relationship with Mr. Williams prior to that, is that right?
We was never in a relationship. We were dating, but not a relationship. I don't know if that's a difference.
All right, so, well, let me, let's talk about that a little bit. In terms of the relationship, there was some kind of relationship between you and Mr. Williams that was more than friends. Is that fair to say?
Yes, sir.
All right, and I'm not, ma'am, it's not my intention to embarrass you or anything here, but was that a sexual relationship?
Yes.
Okay. Was it ever, you would not categorize this as a dating relationship, though? Is that what I'm meant to understand?
Correct. Yes, sir.
How long did this, I know you said that you had known Mr. Williams through relatives for a period of years, or for neighbors, I'm sorry, for a period of years.
Mhm.
Is that right? Is that a yes?
Yes, sir.
All right, that's okay.
Yes,
She's recording, so the uh-huhs and that kind of thing are hard
Yes,
to.
sir.
How long would you anticipate, or to your best of your recollection, how long was the relationship, I guess, sort of the enhanced relationship between you and Mr. Williams?
About only a couple of months. It has to be about 3 to 5 months.
About three to 5 months. And that ended several months before this July incident?
Yes. Yes, sir.
The evening of this incident, did Mr. Williams bring anything to you? Did he have gifts or vitamins or anything like that evening?
I can't remember if he had.
Okay. Do you remember if after Mr. Williams left, he had left any property of any kind behind in the home?
No, sir. I don't remember if he did.
All right. Let's talk about, you say that there was this scuffle. You indicated that when you gave your statement, you indicated that he had a couple of things in his hands when he came up the stairs. Is that right?
I know you have a cigarette.
In one hand. Do you recall which hand the cigarette was in? If not, and if not, that's
No,
okay.
sir.
I realize it's been a while.
That.
Did he have anything else in his hands at this point?
I can't remember if he did.
Do you remember telling the police that he had a bottle in his hand?
No, sir.
No, you don't remember, or no, he didn't?
No, sir, I don't remember.
Okay, that's fair. And at some point when he gets to the top of the stairs, your testimony is that he struck you. Is that right?
Through the confrontation?
Yes.
Yeah. He
All
did.
right.
Yes,
Did he strike you with his right hand or his left hand?
I can't remember.
Okay. Do you remember if it was like an open palm slap? Was it a punch? Or was it a push, or what's the best?
Punch wasn't that time. Open.
So it was more like an open palm
Like a
slap.
slap. Yes, sir.
I see. And then you indicated that he immediately then, or immediately after this incident, he turned around and left the house.
Yes, he did.
All
Yes,
right.
sir.
And you didn't see him again that evening?
No, I did not.
Redirect.
Yes, Your Honor. You said the punch wasn't that time.
Yes, sir.
You alluded to it previously, but there were other violent incidents from Mr. Williams, correct?
Yes, sir.
Does it make it difficult to remember exactly what act happened on what date?
No, sir. I'm sorry. No, sir.
Thank you.
You're welcome.
And you're sure your doors were closed and locked that evening, correct?
Yes, sir. It's a school night.
So if you were to enter your home, you would have to open your doors, correct?
Either open it or break in. Yeah. Yes, sir. Yes, sir.
Thank you.
You're welcome.
Now, you said that you had broken up a few months prior to this.
Yes, sir.
And so I just want to make clear, you did have a relationship with him, correct?
Yes, sir. Yes.
Thank you.
You're welcome.
And at this time, people don't have any further questions for this witness.
May this witness be excused from
You
the
may, Your Honor.
from the fence?
Yes, Your Honor. Thank you.
You may be excused, ma'am.
Thank you.
Do the people have any further proofs?
No, Your Honor.
Do the people rest?
They do, Your Honor.
Mr. Palmer, any proofs today?
Not for today, Your Honor. Thank you.
Motion for bind over?
Yes, Your Honor. Based on the testimony of the victim, Alicia Williams, people would seek to bind over on count one, home invasion of the first degree, as the defendant entered her residence without her permission, and he had to do so by opening a door, which means it would fall under either breaking and entering category or the entering without permission. He did not live at this residence. He never lived at this residence. Didn't have permission from the legal tenant, Alicia Williams, to enter. While entering, present, or exiting, he committed a larceny by stealing her phone, and he committed assault by putting his hands on her. And he did so while Alicia Williams and her children were lawfully present in that residence, and therefore I believe every element has been met for count one, home invasion of the first degree. For count two, larceny in building, he stole her cell phone while he was inside of that building, her residence. She testified she didn't get it back for weeks. She had to fight to try and keep the phone. And he took it from her with force. I believe that means count two, larceny in the building, has been met. Count three, domestic violence, second offense. This is a misdemeanor which carries over, but I would note she testified they had a relationship. It was sexual in nature. It was serious enough that a breakup had to occur. And he put his hands on her when she did not want him to. He had no legal right to. Therefore, I believe that all the elements for count three have been met. And then the people will be requesting two additional counts. That being an added count four, interfering with a crime report by committing a crime. That being PAC code 750.483, A as in apple, 2B as in bear. As the defendant knew that she was attempting to call 911, she said very clearly she was calling the police, and he worked to take the phone from her. And therefore, I would ask that you bind over on this, as he used force against an individual, and in using force committed the crime of either larceny from building or interference with electronic communications. She tried to call the police. She said she was calling 911, and he stopped her. She even threw the phone and yelled for her children to call 911 for her because he was stopping her. And they weren't able to do so because he ran and took her phone and ran out of the building with it. She wasn't able to call the police till she got to her mother's home. Therefore, I believe that the elements for that crime have easily been met. Which brings me to the last count that I'm requesting, an added count 5, the interfering with electronic communications. PAC code for that being 750.5405A as an apple. She tried to make an authorized electronic communication through her telephone to call the police, get help, and he stopped her. Therefore, I believe all the elements for that have been met. She testified about the venue, the date, and she successfully identified the defendant. I'd ask that you bind over on the 3 counts that were charged when we began today, and the 2 additional counts that requested a result of today's testimony.
All right, just for course edification, count 5 is the interfering with the electronic communication.
Correct, Your Honor.
And count 4 is the interference with I got the PAC code. And
Crime report.
the crime report. Okay. And then what is the penalty on count 4?
On count 4, it is a 10-year discretionary consecutive. Count 5 is the 2-year felony.
Response?
If I could have just a second. Thank you. Your Honor, I understand that this is a probable cause standard, is not a beyond a reasonable doubt standard today. I would ask that, well, a couple of things. I would ask that the court not bind over on any of the matters and leave the matter only as the domestic violence for lack of probable cause. Again, Your Honor, I realize that the court is not in a position today to determine the strengths and weaknesses of the testimony or any of those kinds of things, but I would suggest to the court that there was no testimony today that specifically indicates that the defendant entered that property, certainly without, the testimony was without consent, but how he entered that property is unclear to me. She indicated she did not see him enter that property. So I would ask that that matter be dismissed. With regards to the larceny in the building, I would point out that certainly the testimony today was that he took the phone. It's not entirely clear that he took the phone from her. I realize she testified that it was his phone, but I guess my point being is, and this goes more to the requested added counts. I think that the issue there is that in terms of those added counts, the testimony as I understood it was that he did not take the phone from her, that he started to, or maybe attempted to take that phone, but that she was then ultimately able to toss that phone to her children. She then said that he ended up with the phone, but how he got that phone was unclear through the testimony. So I would ask that the court not bind over on those charges. Again, Your Honor, I certainly acknowledge that this is a low standard.
Any response?
No, I think the testimony was pretty clear. She said she was going to call the police. She was actively trying to call 911, and he worked to prevent that. And even if he hadn't been successful, she'd still been able to call the police, the elements for these crimes would still be there, as each of them has an attempt built into each individual statute. If you attempt to stop someone from calling the police, you're guilty of that crime as it stands. If you attempt to stop someone from making an authorized electronic communication, you're guilty of that charge as it stands. Thank you.
All right, so the standard for preliminary examination purposes is probable cause. It's the second lowest standard in criminal law, the only lower standard being reasonable suspicion. The testimony was from Alicia Williams. She testified as to date, which is July 22nd, 2021. She identified the defendant in court. She testified as to venue in the city of Lansing, Ingham County, was 1217 Highland Avenue. She testified to the location, and then we have the elements of the offense. She testified that the defendant did in count one either break and enter, depending on if you look at the way this front door was, or enter without permission, which seems to be obvious since she did not give him permission to be in the house. In a place she lived, which is 1217 Highland Street, Lansing. And while present, entering or exiting, did commit a larceny. That's the stolen phone aspect of it. Also, there was an assault, at least a pushing from the testimony of Miss Williams while the defendant was entering or present, and that Miss Williams was lawfully present in the building, which raises it to home invasion first. I believe that the elements have been met on count one, and I will bind over to circuit court on count one, which is the home invasion first. As to count two, larceny in a building, there's testimony that she either threw the phone, and then it was taken from her and then given back to her at some other time. But it was obvious that the phone was stolen from her inside the building located at 1217 Highland Street at a probable cause standard. So the defendant did commit the crime of larceny in a home by stealing a cell phone. That is met by probable cause evidence at this time, and I will bind over on count two, the larceny of building. The count three is domestic assault, which carries over as a misdemeanor with a prior. As to count three, the 1 year carries over. As to the two additional counts, I'm familiar with both of them. Count four is interfering with a crime report, the 10-year felony under 750.483A2B. I find there's evidence to indicate that the defendant was guilty at the date and time testified to of interfering with the crime police report or the crime report pursuant to that felony. And so I'll bind over a probable cause level to circuit court on count four. And count five, which the court is intimately familiar with. The defendant prevented, obstructed, or delayed by any means the sending of an authorized communication. He obviously stopped her or prevented her from using a cell phone in order to seek help in this event, and that he did so willfully and maliciously, saying several things, and that he did the act on purpose with the intent to prevent, obstruct, or delay. With that probable cause standard, I believe that the PAC code for the code for that is MCL 750.540 parens 4, that 2-year felony count 5 has also been met by a probable cause evidence on the date and time by the witness Alicia Williams, and therefore I'll bind over on count 5. So counts 1, 2, 4, and 5 are bound over. Count 3 carries over as a misdemeanor. Anything else? So the next date will be in circuit court. Anything else for the record, Mr. Pfeiffer, or from the people?
Not from the people, Your Honor.
Anything, Mr. Palmer?
Not from the defense today, Your Honor. I would just ask the bond.
Okay. Any objection to bond continuing?
No, Your Honor.
Okay. With that understanding, bond is to be continued, and that's all for the record in this file. Mr. Williams, keep in contact with Mr. Palmer, your attorney. Your next dates will be in circuit court. Okay. All right. That's all for the record in the file.
Thank you.
Thank you.
Mr. Walker, would you identify yourself and the case you're here on?
Yes, good morning. My name is Ted Walker. I was here for the case with Brentwood Apartments. I'm sorry, I'm trying to get to a private area.
But you're reading now. No, yeah.
Do you have a case number, sir?
Yes, I do. Just a moment. My case number is 2202458. Larry Thomas Franklin.
2200248.
It's a civil case. Case is dismissed. County attorney for civil department, it was never scheduled for. It was scheduled for a final pretrial yesterday. The case is ultimately dismissed. I think we had-
All right, sir, that's not on our docket today. It appears that it was originally scheduled for a final pretrial yesterday and it was dismissed. So I would confirm that with the civil department with the city of Lansing. But that's, right now it appears the case was dismissed. I'd follow that up with the civil department.
Um, maybe could you tell me briefly what that means?
It means, it means that the moving party, the plaintiff, dismissed the case at some point prior to yesterday.
Are they trying to evict me? I guess that to be blunt, I'm sorry.
Right. It's a landlord tenant case. And so it was on the schedule for yesterday, but I believe it was dismissed before it made the final pretrial yesterday. So it was set for yesterday and then it never came to the record because it was dismissed yesterday.
It was actually dismissed on September 6th.
It's actually was dismissed on September 6th, according to our computer.
Well, will I have time to pay? I guess is where I'm getting at.
I think you'll have plenty of time since there is no longer an eviction notice for you. I would contact the civil department of the city of Lansing because you don't have an eviction on you anymore by the plaintiff.
All right. Well, I will make sure I hustle up on my end. I think the court for his time.
All right. Thank you, sir. Take care.
Good day. Good day.
Zero 2653. People of the state of Michigan versus Kendrick Watkins. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good afternoon, or good morning, Your Honor. Assistant Public Defender Stephen Flagel, sitting on behalf of Mr. Watkins.
And sir, you are Kendrick Watkins?
Kendrick Watkins.
Thank you. Mr. Wisty, this is the time set for preliminary examination. How are we proceeding today?
Your Honor, we'll be running the examination.
All right. Any preliminary matters, Mr. Fagelson, before we get started?
Just two, Your Honor. The first one is, as the court knows, this is adjourned from a few weeks ago for a couple of reasons. One, I was in a felony circuit court jury trial. But second is Mr. Watkins had expressed a desire to retain his own attorney. I've had contact with that attorney, Mr. Matt Samuels. I do know at this time he has not been retained. I understand they're still working on a few things. I don't know if that retainment is occurred, but I'd like maybe a week adjournment to allow him and his family to work through that, see if they're able to retain Mr. Samuels or not, Your Honor.
Mr. Wisty, your position on the request for an adjournment?
Your Honor, the people are prepared to go. I would leave it to the court's discretion how it wants to maintain its docket.
How many witnesses do you have today?
Just one.
Just one. Mr. Watkins, well, Mr. Feigelson, are we certain that next week we'll be back and Mr. Samuels will be the lawyer, or is it still kind of up in the air?
I'm not certain, Your Honor. He may be better address that, but I know, I think they're close, but I don't know if they're ever gonna, if it's ever gonna
Right.
happen. I can't really speak.
mean,
for
I'm fairly
that.
sure like $500 right now. I mean, kind of pretty sure that they have a lawyer, but I'm not really all the way sure. Not.
Well, you always have the opportunity in circuit court to get somebody else to represent you. But my concern is we adjourn it for another week and you're incarcerated another week on a cash surety bond here. And so I'd like to keep this moving. If Mr. Wisty has his witness today, let's go ahead and proceed. And then you can always, you're represented by Mr. Feigelson. He's a public defender. He can cross-examine and he can contest any charges brought against you. But you always have the opportunity with Mr. Samuels to hire someone else, okay?
I understand.
All right. So anything else, any other preliminary matters before we get started?
Your Honor, the people would like to submit a judgment of a sentence here into the evidence that is certified. It is for case number 21306 FH. And this concerns the defendant Kendrick Anthony Watkins.
Mr. Feigelson, you've had the opportunity to see this?
I do, Your Honor.
All right.
No objection.
All right. I'm gonna have this marked as an exhibit then. So let's have it marked as People's Exhibit 1. All right. So motion to admit People's Exhibit 1 without objection. Exhibit 1 is admitted, Mr.
Yes,
Feigelson? Okay. All right, Mr. Wisty, you may proceed.
The people will call their witness Zachary Johnson, if I may be excused.
You may.
Thank you, Your Honor.
All right, officer, I'm gonna have you stand right here and state your first name and spell your last name for the record.
Zachary Johnson, Johnson.
And raise your right hand. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, please have a seat in the witness chair and project as loudly as you can for recording purposes.
Yes, sir.
Okay,
Permission to proceed, Your Honor.
you may.
Again, could you state your name for the record?
Zachary Johnson,
Where are you employed?
Lansing Police Department,
What's your position there?
night shift patrol officer.
How long have you been in that position?
I've been in that position for about 1.5 years, and I've been with Lansing Police for 6 years.
Were you working on October 2nd of this, October 2nd of 2022?
Yes,
When you were working, were you dispatched to a shooting?
I was dispatched to a shots fired call.
Where did that call come from?
The call was Burger King in Frandor on East Saginaw. And
When you, oh, go ahead.
I'm sorry, dispatch advised several subjects for shooting, and one of the accused was wearing a black sweatshirt.
And you went to that Burger King?
Shortly, it was actually south of that area. As units came into the area, we called out that there were several people running in different directions. And one of my partners called out that he saw 2 of them running through a different business south of there. And that's when I saw 2 subjects matching the description running.
Okay, so when you arrived on the scene,
Yes.
where were you exactly? when you saw the suspect?
I believe it was Wendy's, which is south, probably about 1/4 mile to a 1/2 mile from Burger King.
And that's in the city of Lansing,
Yes,
County A.
yes.
When you saw the suspects, what happened next?
I saw them running through the drive-through, and I thought that was immediately interesting because people don't typically run through drive-throughs. I saw one subject running with his hands in his front pockets of his hoodie, and I got out of my vehicle. And I immediately ordered them. I identified myself as a police, and I said, "Stop."
And what happened after? you said
Neither subject stopped, and he continued to run with his hands in his front hoodie pocket.
And are you pursuing both subjects? Are they next to each other?
I had a partner with me, and he took one subject, and I gave chase to another subject.
So you're chasing one subject, he's got his hands in his hoodie pocket.
Yep.
What happened from there?
I pulled my taser, and I told him several times, "Stop, you're going to get tased." I repeated that loud and clearly. Eventually, the subject reached into that pocket. A firearm fell out of the pocket, and I heard it clang across the ground, and then I took the subject to the ground and took him to custody.
You recognize that subject here today?
I do.
Can you point him out? Can you identify something he's wearing?
Sitting right there wearing a Ingham County jumpsuit.
May the record reflect the witness has identified the defendant?
Any objection, Mr. Ferguson?
No, but I'll cross him out of here.
All right. Let the record reflect the witnesses identified the defendant.
So after you, at some point, did you recover this firearm?
I did. After the subject was secured in handcuffs, I located the firearm in the parking lot and made it safe.
How do you know it was a firearm?
I've been in law enforcement for 9 years, and I'm very familiar with pistols.
No further questions, Your Honor.
Cross-examination, Mr. Ferguson?
Yes, Your Honor. Good morning, Officer Johnson.
Good morning.
So you've been a police officer, you said, for 7.5 years, is that right?
9 years total.
Okay.
6 with Lansing.
What other office were you in? Right?
Eaton County Sheriff's Office.
Okay. I'm assuming you went to the police academy, is that correct?
I did.
You assume you were lawfully trained to make accurate police reports, is that correct?
Yes.
How to investigate a case as well, is that correct?
Yes.
And you said you were on shift that night, is that correct?
Yes.
You were working with a partner, is that correct?
I was not. I was solo in the car, but several officers came into the area on the call. There were several officers involved.
You mentioned you and another officer saw two individuals at the Wendy's, is that correct?
Yeah, running.
And they both have black hoodies on?
No, just one.
What hoodie did the other individual have
It
on?
was light colored, I think. I can't remember.
And then they both split off, is that correct?
They were kind of running parallel. I ran after one, and my partner ran after the other.
And one of them commands to stop, is that correct?
Yes.
And then you said eventually you caught up to them, is that correct?
Yes.
And you said did you hear the gun go off or you just saw it drop to the ground?
I saw it drop out of his pocket. His hands were in front of him the entire time, and I saw it drop out of his pocket onto the pavement.
Okay. And you said you were able to, can you tell anything about that individual, what they were wearing that night?
Black hoodie.
Besides the black hoodie, when you arrested him, could you give any facial description of what that person looked like?
Well, he had a mask on at the time, but then we took it off as he went and got booked out of jail.
And before that night, have you seen that individual before?
I'm sorry?
Before that night, have you seen that individual before?
No.
Now, how'd you know it was Mr. Watkins?
He's identified himself.
No, I have no further questions for this witness.
Any redirect?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Without objection, the witness is excused. Mr. Wissey, any further proofs?
No, Your Honor.
Mr. Feigelson, any proofs today?
No, for purposes of exam, Your Honor.
Thank you. Motion for bind over, Mr. Wissey.
Your Honor, the people would move to bind over on both count 1 and count 2. Count 1 is weapons carrying concealed. We heard testimony from Officer Johnson that witnessed the defendant who I identified running with a gun inside a hoodie pocket that fell out. That happened in Lansing County, Bingham. The elements of that have been shown to a probable cause standard. On count 2, it's firearms possession by felon. Testimony has demonstrated he was in possession of a firearm. Certified conviction entered as Exhibit 1 demonstrates that he did have a felony conviction. And count 3 would go along with the other 2 felonies as a misdemeanor, Your Honor.
Thank you, Mr. Wissey. Response, Mr. Feigelson.
Yes, Your Honor, I know this is a low standard of proof at a preliminary exam today, Your Honor, but I don't believe there's enough evidence even at the standard to find over that I would ask that this matter not be found over. Thank you.
Thank you, Mr. Feigelson. So this is a probable cause standard at preliminary examination. Probable cause being the second lowest standard in criminal law. The the case, so the court would find that the location of 3121 East Saginaw Street, which is approximately the Wendy's area of Frandor in the city of Lansing, Ingham County, state of Michigan, that on or about October 2nd, 2022. So that's location, venue, date, and then identification was made by the officer Johnson in court of the defendant for ID purposes, which leads us to the elements of the crime. The officer testified that this defendant did he saw the firearm or handgun drop from his person, and then was arrested in relation to the events that happened. So in count one, I believe that the witnesses testified at a probable cause standard that the defendant did carry a dangerous weapon, a handgun concealed on or about his person, contrary to the law of the state of Michigan, which dovetails right into count two, which this defendant with a prior felony record did use or carry a firearm when ineligible to do so because the defendant had been convicted of a previous felony and the requirements for gaining eligibility had not been met, contrary to the law of the state of Michigan, that being a 5-year. I believe that plaintiff's exhibit one indicates the prior felony and that there's no indication that the prior, and this felony is only within a year's time of the event, maybe a year and a half. So the elements have been met in regards to count two by a probable cause standard. Count three will carry over to circuit court in relations to count one and two. So the court binds over on counts one and two at a probable cause standard to circuit court. Mr. Watkins, keep in contact with your attorney, Mr. Feigelson, or Mr. Samuels, depending, and they'll tell you your next date in circuit court. Your time in district court is done. Okay, sir? All right. Anything else for the record, Mr. Whiskey, in docket 22-02653?
No, Your Honor.
Anything, Mr.
No,
Feigelson?
Your Honor, thank
All
you.
right, thank you. That's all for the record in this file. And I'll hand exhibit one back to you, sir.
Thank you.
And then, does he need to sign anything, Mr.? And sir, you are Robert Johnson?
Yes, sir.
All right. This is the time set for continuation of a previously started preliminary examination. Mr. Whiskey, how are we proceeding today?
Your Honor, we'll be proceeding. The people will be calling for additional witnesses.
All right. uh, With that understanding, we've already admitted people's exhibits 1, 2, 3, and 4. And was it witness Hall who already testified?
Yes, Your Honor.
All right. You may call your next witness.
Your Honor, I would call Seamus McMahon to the stand. Also for purposes of sequestration. Please leave. Thank you.
All right. I'm gonna have you stand right up here. State your first name and spell your last name for the record.
Seamus, last name Ken,
And how do you spell your last name?
MCCANN.
Okay. Please raise your right hand. Do you solemnly, your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, have a seat right here and please project for recording purposes.
Permission to proceed, Your Honor.
You may.
Could you state your name one more time just for the record?
Seamus McCann.
Mr. McCann, do you know a man by the name of Robert Johnson?
Yes, I do.
You see him here in the courtroom today?
Yes, I do.
Could you point him out and identify something he's wearing?
Blue jumpsuit.
May the record reflect the witnesses identified the defendant.
Without objection? Without objection, the witnesses identified the defendant.
Can you tell us how you know Mr. Johnson?
I don't know him physically, or I usually call him uncle. He hangs out at Aldo Park and helps me out with cigarettes and sometimes cigarillos when I need them sometimes.
Where is Aldo Park?
Aldo Riverfront Park.
It's in the city of Lansing,
Yes, it is.
Hingham County.
Yes, it is.
And that park, do you live there? What's the situation?
I'm currently homeless, so yeah, we stay there and stuff like that. And see, sometimes I just sit on the grass and stuff like that.
Does Mr. Johnson also stay in that area?
In that area, yeah, he doesn't stay at the park, but he comes and stays in the area sometimes. And sees the people.
So this is a person you interact with in that park?
Yeah.
About how often would you interact with him?
Say he comes up there, say every week.
Did something happen every week starting when?
It's like he started coming every week. Like I don't know what Pacific Day served, but he started coming every week, and it was like during the summer because everybody's coming there during the summer.
About when, how long ago did you meet him? And roughly?
Say 3-4 months.
And then, so roughly 3-4 months, you
Yeah.
first came in interaction with him.
Yeah, roughly.
From there, you're seeing him roughly every week.
Yeah.
Did something happen then on October 11th, 2022 between you and Mr. Johnson? When did you first come in contact with him that day?
The first contact I came with him that day was when I seen him and I asked him, does he have $1 for a pack of cigarillos? And he said, yeah. He sent me to the store, and I went to the store. There was no issue.
What happened when you came back from the store?
When I came back from the store, there was an altercation that was going on, and
who was involved in the altercation?
It was Mr. Johnson, me, and my fiance.
Was your fiance there when you came back, or did she go to the store with you?
She was with Mr. Johnson.
So when you're coming back from the store, you see Mr. Johnson and your fiance.
Yeah, and they're having an altercation.
Who is your fiance? What is her name?
Lisa Trine.
What did you witness in the altercation? What were you looking at?
I was looking at them two arguing, and pretty much Mr. Johnson saying we're mooch lovers and homeless lovers and something like that.
What happened from there?
And then it got to violence, and he pulled an eagle knife out and started swinging towards my fiance, and I moved out the way, and that's when I hold my wrist up like this, and that's when I got sliced.
How close was he to your fiance when he swung the knife?
As like at least this peripheral.
If you hadn't jumped foot.
So let the record reflect about 2-3 feet?
Yes, sir.
Okay.
So roughly 2 to 3 feet when he swings the knife.
Yes, sir.
And then what were you thinking when you stepped in there? What's going through your mind?
I mean, honestly, sir, honestly, it was either my wife or me, so I would honestly pick my wife to get saved before me. That's honest truth. That's what anyone would do.
Your Honor, if I may approach.
May,
Record reflect, I'm showing the witness what's been marked as plaintiff's exhibit 5. Can you tell me what that is?
Knife.
Does that look like the knife? Do you recognize that knife?
Yeah, I recognize it.
Where do you recognize it from?
That's not the cover.
Your Honor, I would like to move to admit the plaintiff's exhibit 5 into evidence.
any objection, Mr. Abbott?
No, thanks.
Without objection, plaintiff's exhibit 5 is admitted into evidence.
Mr. McMahon, I'm going to show you another picture here.
Okay.
May the record reflect I'm showing the witness with the plaintiff's exhibit 6.
Record may so reflect.
Can you tell me what that is?
That's the knife. No conform.
And when you say that's the knife, just for the record, that knife is what knife exactly? Can you be more
The
specific?
evil claw knife.
Is that the knife that Mr. Johnson used?
Yeah, it was when he was swinging around in the current situation.
People would move to enter plaintiff's exhibit 6 into evidence.
Any objection?
No.
Without objection, People's Exhibit 6 is admitted into evidence.
May the record reflect I'm showing the witness what's been labeled as plaintiff's exhibit 7. Can you tell me what that is, Mr. McMahon?
The evil claw knife.
Is that the claw that Mr. Johnson used?
Yes, it is.
And that would be on October.
I told you already.
People would move to admit plaintiff's exhibit 7 into evidence, Your Honor.
Mr. Abbott?
Seems a little repetitive, but no objection.
Okay, thank you. So without objection, People's Exhibit 7 is admitted. The only difference between 6 and 7 is 7 looks to be a zoomed in photograph. Thank you.
After Mr. Johnson cut you with the knife, what happened from there?
My wife continued to call now. She proceeded to call 911 and authorities, of course, and they arrived. Mr. Johnson tried to flee, and my wife tried to stay with him, and I wrapped my hand up with a t-shirt, like a t-shirt of my body, and I wrapped my hand up.
Your Honor, may I approach?
You may.
I see the previous exhibits.
Yes. Here's all the exhibits that have been admitted.
After, so why did you wrap it with a towel?
Because it was completely gushing at the time.
Did eventually police become involved?
Yes, it did.
Did you go to a hospital eventually?
Yes, I did.
How did it come to be that you went to a hospital?
Because of the causes that the situation put me there of Mr. Johnson cutting me, I had to have 8 stitches in my arm.
Your Honor, may the record reflect I'm showing the witness what's been labeled as plaintiff's exhibit 4.
That was previously admitted.
Correct.
Okay.
Can you tell me what that picture is?
It's my arm.
Record reflects, I guess. I was going to say, may the record reflect he's identified plaintiff's exhibit 4, but I think that was already covered.
Correct. It's admitted, but he's identified Exhibit 4 as being his arm.
Yes, Your Honor.
Thank you.
But I would believe I don't think that was necessary as I asked him what it was. May the record reflect I'm showing the witness what's been previously admitted as plaintiff's exhibit 1.
That's my arm in open form when I was beginning to clean it.
And may the record reflect I'm also showing the witness would have been previously marked as plaintiff's exhibits 2 and 3. Those 2 pictures, sir, can you tell me who's in those pictures?
Me.
And when were those taken?
That's when I was taken in the emergency room and it was Christine that cleaned my hand. And when one of the officers was there, they was taking pictures of my hand.
No further questions, Your Honor.
Thank you. And for the record, so the witness is identified and put into context previously previously admitted exhibits 2, 3, and 4, and 1. Or 1, 2, and 3. Any cross-examination, Mr. Abbott?
Thank you.
Good morning.
Your Honor, just if I may brief, I believe you did also identify people as exhibit 4. That was brief.
Yes, I believe you did. Thank you. So you mentioned that Mr. Johnson was teasing you or taunting you about money?
Yes, sir.
Okay. And first you said that he sometimes helps you out with cigarettes and cigars. Is that what happened that day?
Yes, sir.
And you said you asked for $1, but he didn't give you cash. He gave you his card, right?
Yes, sir.
And it was before you, and you went to buy the cigars or
It was cigars.
with the card?
Yes, sir.
And Mr. Johnson and Ms. Trine stayed in the park.
Yes, sir.
And what store did you go to?
Quality dairy off of, I want to say Larch Street, Larch and Cedar Street.
Right there where large branches
Burger King, yes.
Saginaw?
Yeah.
Yeah. Okay. And so you walked there
Mhm.
and walked back?
Yes, I did.
Okay. And you bought more than just cigars, right?
Yes, I did.
But when you left, the agreement was you were just going to buy cigars?
Yes.
So you used more of his money than he thought you were going to use?
Yes.
Okay. And is it Ms. Trine received some sort of SSD benefits or some income from someplace?
Yes, she does.
And that was the basis of his argument with you?
Yes, it was.
His criticism that you were using her money to survive on?
That's what the statement was. Yes.
And let's see, you're what, 28, 29 years old?
28.
And you weigh about 180 pounds?
I wish 215.
215, so 215 pounds, 28 years old. You're pretty strong
I'm sorry.
and healthy,
I'm sorry.
and you live on the streets part of the time or most of the time,
Yes.
and you have to take care of yourself.
Yes.
And in fact, Mr. Johnson, when you decided to spend his money, you decided there was nothing he could do about it, right? You weren't afraid of it.
Nah, I'm not saying I wasn't afraid of it at all.
But you didn't figure it would make any difference if you spent a little more of his money.
I told him I was gonna pay the $1 back, and that's when we got to the situation we got.
Okay,
I had the dollar right then and there.
okay. So you and Miss Trine are both homeless? You and Miss Trine are both homeless, is that? Okay. But she's a good friend of yours and she's your fiance. And how long have you known her?
2 years. I
Okay,
know for 6, we've been engaged for 3.
okay. And she's a much smaller person than either you or Miss Johnson, right? She's,
Yes.
okay. And due to her cognitive situation, she's easily taken advantage of by people?
Not directly, yes.
Well, okay. And you kind of look out for each other?
Yes, Your Honor, if I may, I would just like to let the witness know that everything he says is on record by definition, based on the previous statement.
Okay, but with that note, I mean, we're on the record, so, okay, so, but you're fine, just keep testifying the way you are. Okay. So, when you came back, you had the cigars you bought,
Yeah.
and what else did you get?
Just a black and mild.
Okay, and say that again?
A black and mild.
Okay, black and mild.
Yeah.
Okay. And so you had this argument with Mr. Johnson?
Yeah.
And you said you stepped in to protect Miss Trine. Was she, when you
She
came,
was standing in front of me.
she was standing?
She was standing in front of me like here. Want me to do like this because it was here, I was right here, and he went to a slash, and that's when I pushed her beside him.
So it's your testimony that he took out his knife while she was standing right there?
Yes, sir.
Because, oh, wait a minute, he was arguing with you though about the money?
Yeah, there's arguments, heat argument, and got to the ping pong and reaching in his pocket and pulled out his knife. That's when we started swinging.
Okay. So when you came back from the store, was she sitting or standing?
She was literally standing on her feet and they was arguing with each other in the park.
Okay. And what were they arguing about?
Obviously, when I walked over there, when I got all over there, she told me to give him his car back and give him his sticks back, that he's degrading us, calling us we're bums and we need to make money and stuff like that, and find jobs and stuff like that. That's all they was arguing about.
Okay.
And then they said and then he said that he was trying to get with trying to flirt with her or something like that. And I didn't think anything of it.
You didn't think anything of it?
I said I didn't.
Didn't it make you angry that he was accusing you of being a bum?
No, sir, because I know what I am.
Okay. Did it make you angry that he was accusing Miss Trine of being a bum?
I mean, we're people, we're all human.
Yes.
So no, honestly, I don't let another person, what they say, bring me down, honestly.
All right. So you inserted yourself in between Miss Trine and Mr. Johnson?
Yes, I did.
Okay. And at some point, so was he walking towards you or was he walking away from you?
He was walking
Towards her?
towards a situation where when right here, Miss Trine and Mr. Johnson were standing right here.
Okay.
He was walking towards, and I seen him hit his hand in his pocket.
Okay.
And then when he reached to pull his hand out of his pocket, I noticed that there was something, physically noticed something was in his pocket. So that's
Okay.
when I pushed her aside, and when we get to swinging, that's when I got slashed.
Okay, so you got slashed and that was the end of the fight?
I mean, pretty much, because everybody that was there got to run in, and Miss Trine called 911, and that's when Mr. Johnson got to walk away.
Okay, so there was a slash on your wrist.
Yep.
And then he starts walking away
Yep.
and you wrap your wrist in a t-shirt
Yep.
and Miss Trine is following Mr. Johnson?
Yep. And calling 911.
Okay. And this happened in Adado Park?
Well, I call it Aldo, but yeah.
Okay, Aldo Park? And that's right on the river there in
Yeah.
Lansing? And and you were on the west side of the river, the LCC side of the river?
No, right by the Happy's side.
Okay.
Right in front of Happy's Pizza.
Okay, so
That
you're on
area.
the east
Yeah.
side of the river.
Yeah, east side.
And where did Mr. Johnson go?
He started walking towards the not over the bridge, but towards what's that street car?
Saginaw?
Sorry, Saginaw. Thank you.
Okay, so he headed up towards Saginaw and she followed him?
Yep, she started walking with him, and she was staying down with the 911 operator, talking to them, trying to make sure she knows where he's going.
Okay. And he's got much longer legs than her. It must have taken some effort on her part to keep up with him.
I guess. I don't know.
Were you watching her as she did that?
No, I was making sure my hand was okay. So
Okay. So you didn't see how far she chased him or pursued him?
no.
Nothing further for this witness. Thank you.
Any redirect?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Mr. Abbott, may this witness be excused? Without objection, you're excused, sir.
Thank you, Your Honor.
And the people may call their next witness.
People call Lisa Trine. I may be excused.
You may.
Better.
Fine, I'm gonna have you stand right up here. I'm gonna have you state your first name and spell your last name for the record.
Lisa Trine, T-R-I-N-E.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. Go ahead and have a seat here, and I'm gonna have you project as loudly as you can for recording purposes. Okay, ma'am? All right, is that a yes?
Yes.
All right, thank you.
Permission to proceed, Your Honor.
Yes, please.
Could you state your name one more time for the record?
Lisa Trine.
Ms. Trine, do you know a man by the name of Robert Johnson?
Yes, I know the person.
Do you see him here today in the courtroom?
Yes.
Can you point him out and identify something he's wearing?
he is wearing a jail uniform.
May the record reflect the witness as identified defendant.
And any objection to the witness identifying the defendant?
No.
You indicated he was wearing a jail outfit.
Mhm.
Is that a yes, ma'am?
Yeah.
Okay, thank you.
How do you know Robert?
By being homeless.
When you're homeless, where do you primarily live?
Anywhere at the park, behind buildings, anywhere.
On October 11th of 2022, where were you staying?
At a park,
What city is that in?
Lansing, Michigan,
What county?
Ingham.
When you were staying in that park, did you have interactions with Robert?
He said hi to us, and that's about it, hanging out with them.
How long before there was an incident that happened on October 11th, correct?
Mhm.
How long before that incident had you known Robert?
About probably a month or two.
And then what happened on October 11th?
He come up looking for my man. And I
Who
told
is
him,
your man?
Seamus McCann. And I told him he's out and about getting food for me and him. And if he weren't, he could wait for him. So he did, me and him talked. I was packing up because we was planning on moving. And so he waited. And then my man came, gave us food and stuff.
And what happened from there?
Then he offered my man to buy a pack of sticks.
Again, my man refers to Seamus McMahon. A pack of sticks, what is that?
Those like the cigars thing.
Like smaller cigars?
Yes.
Okay.
And
So then after he's talking to your man, he offered to give, let's go from there.
then he gave him his credit card, told him the PIN. He went on. Famously. And then he was talking about us downgrading us, about
So
like
who-
not
who-
having.
Who is he at this point?
Yeah.
That's Robert. May the record reflect the witnesses pointed to the defendant.
Record may so reflect.
And at this point, it's just you and Robert alone in the general area.
Yes.
Okay.
And-
What is he saying to you?
And someone else too. And he was downgrading us, like we can't have any money to buy anything. And I got offended of that. So I stand up, because I was sitting down. I said, I have enough money, but I'm not touching it because it's for my housing. Then, like, not only he pulled a knife out on me, he pulled a knife out on my friend also. And my friend left.
Who is your friend?
Chief, he goes like Chief.
You know him by any other name?
No, I don't know if I will name.
So after he pulls the knife, can you give me a little bit more detail of what happened when he pulled the knife out?
Then he put the knife away. Then when my man came back, Seamus, and I told him, I said, give him the credit card and the sticks. I'm not gonna listen to somebody downgrading us.
When
And I told him,
Just back up. When he first pulled the knife on you, did he say anything?
no, it's not for me at that time. It was my friend.
Okay, that was just on chief.
Yes.
Okay.
Then he put it away. Then my man came back. And I told him, I said, give him his stuff. We can find a way to get, a pack of sticks. And plus he was hitting on me there. And I didn't tell Seamus about it because I knew how Seamus was going to react.
So at this point, it's you, Seamus is back. Robert has been hitting on you and
Yes.
insulting you to your financial situation.
Yes.
Robert, what does Robert know at this point? What did you tell Robert at this point?
I told him no because I want to be with Seamus. I'm always shooting him down.
Okay, then when Seamus came back, did you say anything to Seamus about Robert?
No, because I knew what it's going to be. So he didn't like when I told him no. Then he pulled it out. Then this is when he pulled it out on me.
Okay,
Then
that's when he pulls it out on you after you tell him, oh, I understand.
yes, and then before anything, Seamus moved me and I told him, said, watch out, he has a knife. Then he put his hands up like this and he's already sliced. Then to the point I told him to wrap it up, put pressure, then I will be back. I was on the phone with dispatch for the get ambulance and the police, and I ran after him.
When he swung that knife, when he first pulled the knife on you, first he pulled the knife on you when Seamus was present, about how far away from you was he?
About to here, and I'm right here.
How did that,
So let the record reflect 5 or 6 feet.
Yes.
what was
There-
going through your mind when you saw him pull the knife out?
Then I was like, I was afraid. I don't know what he was gonna do with it. And before I said anything, he moved me. When I say be careful, watch out, it's already too late.
If Seamus hadn't moved you, what would have happened?
He was sliced me.
Your Honor, if I may approach.
You may.
Three of the knives. May the record reflect, I am showing the witness what have been previously admitted as plaintiff's exhibits 5, 6, and 7. Lisa, can you look at those and tell me if those look familiar to you?
Yes.
What are they?
There are in a knife. You are my boyfriend's shades with it.
So the witness identified 5, 6, and 7.
Thank you, Your Honor. And then Lisa, I'm going to show you a series of other pictures, just so you're aware. They are kind of graphic. May the record reflect, I am handing the witness was previously admitted as plaintiff's exhibits 1, 2, 3, and 4.
Record may so reflect.
Can you look at those and tell me what those are?
My boyfriend and his arm got sliced and cut.
Do those appear to be what his arm looked like shortly after
Yes.
the incident on October
Yes.
11th? May the record reflect the witness has identified plaintiff's exhibits 1, 2, 3, and 4.
Record may so reflect exhibits 1, 2, 3, and 4 were identified by the witness.
No further questions, Your Honor.
Cross-examination, Mr. Abbott.
Thank you. Good morning. So, do you remember when the police came that day?
Mhm.
And you?
Yes, ma'am.
You have to say yes, because they're keeping a record and
Yeah.
it's hard to type a, okay. Do you remember the police came and talked to you?
Yes.
Okay. And you remember telling them that you told Mr. Johnson that you were gonna pepper spray him?
Yes.
Okay,
Because he was in my face.
okay. And just to be clear about how this all started, you were packing and Chief was there with you?
Yes.
And you were listening to Mr. Johnson criticizing you at this point?
Yes.
And then you and Chief both got up and decided you had enough of that kind of talk?
No. I stayed because that's where me and my boyfriend Seamus stay at.
Okay,
And I was gonna finish packing. Then that's what happened. If she did leave.
okay. Did Chief see the knife, you think?
Yes.
And so the knife came out when Chief was pretty close to Mr. Johnson?
Actually, Mr. Johnson was close to Chief.
Okay, and is Chief a male or a female?
No.
How old do you think he is? Okay, and is he bigger or smaller than Seamus?
a little bit small.
A little smaller? Okay, so you and Chief were there and Chief got up and Mr. Johnson showed him the knife
Yeah,
and Chief left?
yeah,
Okay,
because Chief was trying to tell him me and Seamus was family to him,
okay,
and he was trying to protect me and Seamus.
okay. So Chief was intervening on your behalf then?
Yes,
Okay. And you said you didn't tell Seamus that Mr. Johnson had been trying to hit on you.
no, I did because I knew what's going to happen.
Seamus would get angry?
Yes, and do some other stuff.
Okay, and other stuff by Seamus can get physical sometimes? And people know that about Seamus?
Yes,
Okay. So how many people in the park do you think were within 50 yards of where you were, right? In the neighborhood?
me and this young kid, he's probably 18.
Yeah,
I don't know his name. He was hanging out with us. And then me, my boyfriend, and Mr. Johnson.
okay. And Mr. Johnson's familiar with Seamus's occasional outbursts?
Yes,
Okay. And right after the cut happened, Mr. Johnson left?
yes, he was fleeing.
You pursued him?
Yes,
Okay, and which direction did he go?
he was trying to run from the, how I'm gonna put it. There's a park behind the apartment.
Right?
So he was going to, I don't know exactly where he exactly going, but I followed him
Okay,
into the parking lot
okay,
of the
so,
apartment.
all right. So he went towards the parking lot of the apartments?
Yes,
And that, from where you were, so you guys were on the grass between the apartments and the river?
yes.
And then did he head down towards Old Town or did he head towards downtown?
I don't know that area that well.
Okay, did he head towards,
It was the lights, it's like the lights in the river, like the bridge got all the art on it,
yeah,
the wings.
Right.
He headed that way,
so,
because I stopped, because I didn't have no shoes on.
okay. So you were kind of close to Shiawassee Street Bridge when you started, where the physical fitness equipment is?
Yes,
And then you headed up towards the bridge with all the lights on it?
yes, and I stopped at the parking lot of the apartment, because I
Okay.
didn't have no shoes on.
Did he cross the river?
I don't know.
Okay.
I don't know, I stopped.
Did he pull out the knife while you were following him?
He said he's gonna stab me
Okay,
if I keep following.
okay. But he never did stab you.
No,
So when Seamus went to buy the sticks, what was the agreement that they made about paying for that?
nothing. He was offering us to pack the sticks. You were to buy.
Yeah,
Seamus like, yes. And he went, he bought them, and come right back.
did he buy more than the sticks?
No,
That's all he bought?
yeah,
Okay. And the sticks are like little cigars?
it's like a 5-pack for like 99 cents.
Okay. And they have tips on them?
No.
So just a straight cigar?
Mhm.
And you take the tobacco out and put marijuana in?
Mhm.
And had you been smoking any sticks earlier that day?
Only one.
Okay, so you and Seamus shared a stick?
I don't smoke.
Okay,
He does.
so Seamus had been smoking?
Yeah.
Okay. And that's, just to be clear for the court, that's marijuana, right?
Yeah.
Okay, so Seamus had been smoking marijuana that morning?
Yeah.
Okay. Do you think when he smokes marijuana, he's more or less likely to get physically aggressive?
Objection calls for speculation.
Just,
Response?
Your Honor, just based, she says she's known him for a long time there. Mr. Seamus says he's engaged. She should be familiar with his behavior.
I'll allow it. Overruled.
So do you think he's more or less likely to get physical?
He doesn't get physical. He
No.
doesn't.
No? No. Thank you. Nothing further. Your Honor.
Redirect.
Nothing, Your Honor.
May this witness be excused?
Yes, Your Honor.
Any objection, Mr. Abbott?
No.
All right, this witness may be excused, ma'am. You're free to leave. Mr. Wisty, any further proofs?
No, Your Honor.
Did the people rest?
Yes, Your Honor.
Mr. Abbott, any proofs today?
No, thank you. Your Honor.
Motion for bind over, Mr. Wisty.
Yes, Your Honor. The people would be moving to bind over on count one. That would be felonious assault with intent to do great bodily harm against Seamus McMahon. Testimony here today was that the defendant swung a knife at Lisa Trine. Seamus McMahon got in the way. He struck him and cut his wrist wide open, as we've seen the photographs. That would be a theory. We're binding that over on a theory of transferred intent with intent. In fact, this is kind of a classic law school example of transferred intent, where he's attempting to do great bodily harm on Miss Trine, instead hit Seamus because he stepped in there. In the same vein, we would also be adding a count three, assault with intent to do great bodily harm with the victim being Lisa Trine. That is MCL 750.84, 10 years and or $5,000. The argument there, I believe I've already made it. We've heard testimony. He tried to swing a knife at Miss Trine and would have struck her, but for Seamus stepping into the path of the blade. As for count two, which is a felonious assault, I understand that that specifically requires not intending to commit a crime, that not intending to inflict great bodily harm less than murder by the language of the statute. However, that is not in the jury instructions. The jury instructions are an assault with a dangerous weapon. Here we have the probable cause for an assault committed with a knife, which is a dangerous weapon. I believe there's enough to find that over on probable cause. The issue of it being in contradiction with assault with the counts one. Slow down. The issue of it being in contradiction with count one, right? In this case, the added count three would be a situation where a jury could not find both counts, but it's sufficient to be bound over on a probable cause standard at this time. Similarly, we would also be adding a count four for another count of assault with a dangerous weapon. That would be against Seamus McMahon, violation of MCL 750.928. Violation of MCL 750.82, 4 years and or $2,000. So altogether, Your Honor, what the people are moving to bind over on are count one and count two as charged. An additional count three of assault with intent to do great bodily harm with the victim being Lisa Trine, and an additional count four of an assault with a dangerous weapon, and the victim being Seamus McMahon.
Response.
Thank you, Your Honor. I think the assault with intent to do great bodily harm requires more evidence than we've heard today of an intentional injury, but great bodily harm. The testimony here was this was a momentary single cut, that the fight ended immediately when the cut was made. That intent to great bodily harm, if he'd have continued stabbing, or if the assault had continued for any length of time, or if there was actually any damage other than 8 stitches, there would be, I think, probable cause for great bodily harm. But here, the testimony we heard was that this was an instantaneous or momentary contact. So at worst, Your Honor, I see a felonious assault in either case. But she did testify that she was afraid and that he was close enough, according to her testimony. But still, it's only an assault with a dangerous weapon. There's no evidence of an intent to do any further injury other than make his point, so to speak, with the knife. He was confronted, I guess I'll mention here first, and maybe later in circuit court, that he was confronted with a person with a reputation of having she didn't mention that that Mr. Johnson had tried to hit on her because she knew what was going to happen. So she wanted to keep him calm. He's a young man with a reputation in the community for having physical outbursts. And certainly Mr. Johnson was aware of that physicality. So whether or not it was justified self-defense depends on what other proofs might be available at trial. But at this point, Your Honor, I think there's only a bind over on felonious assault in both situations. Thank you.
Thank you. Response?
Yes, Your Honor, what we have is the photographs and the injury, photographs of the knife and the injury are in evidence. Ultimately, what we have is evidence that Mr. Johnson swung that knife, which appears to be very dangerous, hard enough to slice Seamus McMahon up to the point where the pictures speak for themselves. I would say evidence of swinging a weapon like that with that force is sufficient for probable cause to bind over on assault with intent to do great bodily harm.
Thank you. So it appears that this is a preliminary examination. It's a probable cause standard, probable cause being the second lowest standard in criminal law. Circuit court being, of course, the conviction standard. So the preliminary examination was held. There were 3 witnesses. There were Officer Doug Hall, Seamus Peter McCann, and Lisa Faye Ann Trine. That the location was East Shiawassee, City of Lansing, Ingham County, which takes care of the venue and the location. The date was October 11th, 2022. And I think all 3 witnesses made identification, at least the last 2 did today, who were the victims of the activity there. So as to the count 1 assault with intent to do great bodily harm, it is apparent from Seamus McCann's testimony that he was sliced by the defendant in an action in which he was trying to move his girlfriend out of the way, and it appears that the action was towards her, but he ended up being sliced by a fairly severe slice. There's exhibits 1 through 7, which would indicate the nature of the injuries, and then some of the nature of the knife that was used both in closed and open format. I believe that there's probable cause evidence to believe that the assault was made upon Seamus McCann with intent to do great bodily harm less than the crime of murder, pursuant to MCL 750.84. That's a felony, 10 years. So I believe that's proven by probable cause evidence. In count 2, Ms. Trine said that she was present when the knife was used, when the knife was made to see her, and then the motion was made towards her. It appears that there's another individual, chief, that also saw the knife, but I believe at a probable cause level did make an assault upon Lisa Trine with a dangerous weapon, to it a knife, but without intending to commit the crime of murder and to inflict great bodily harm less than the crime of murder. Contrary to laws of the state of Michigan, that's 750.82. That's a 4-year felony. Those counts 1 and 2 are the original counts in the information. Count 3 is an added assault GBH on Lisa Trine. After the testimony of Ms. Trine, it appears that that count 2 would be a lesser depending on how you read the statute. So count 2 and assault with the felonious assault is a lesser included of GBH. It does appear by probable cause evidence that the defendant did make an assault upon Lisa Trine with the intent to do great bodily harm by making the slicing motion at her by probable cause standard. Contrary 750.84, that's a felony, 10 years. That's the one that ended up slicing Mr. McCann. And then in count 4, so that's also bound over as a greater charge to the count 2, which is the lesser included. And then count 4 in the alternative is felonious assault upon Seamus McCann. Did make an assault upon Seamus McCann with a dangerous weapon, with a knife, but without intending to commit the crime of murder and inflict great bodily harm. Contrary to law of the state of Michigan, that'd be a felony and or $2,000 per that is in violation of 750.82. That's count 4 would be a lesser included of count 1, which would be the felonious assaults, lesser included of assault GBH. I believe they're all to be bound over on counts 4. It's actually 2 crimes, but depending on how it's perused or how it's looked at by the trier of fact, they would get the lesser included in the alternative. So I'll bind over on counts 1 through 4 to circuit court. Mr. Johnson, you should keep in contact with your attorney, Mr. Abbott, in regards to any future dates. in circuit court, but that should finish your time in district court as you are bound over on all 4 counts. Anything for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. Abbott?
No, thank you.
All right, that's all for the record, docket 22-02744. Wilson?
Yes, sir.
All right. So we're on the record in docket 22-02557. That's people of the state of Michigan versus Toby Burleson. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Burleson. He's present and seated to my right.
And sir, you are Toby Burleson?
I am, sir.
Thank you. Mr. Whiskey, this is the time set for a preliminary examination. How are we proceeding today?
Your Honor, we've reached an agreement where Mr. Burleson will plead to an added count 4, an aggravated assault. That is MCL 750.81 A per N1. And in exchange for that plea, the people would be dismissing the remaining counts 1 through 3. There is a sentencing agreement where he would be sentenced pursuant to the sobriety court in 55th. And as a housekeeping matter, we would like sentencing put off approximately 6 weeks in order for him to get the necessary things done to enter into that program.
Okay, so is it a Killebrew to sobriety court
Yes, Your Honor.
in 55th? And sentencing, I think we're at 6 weeks anyway. We're around there.
We're
So
more like at
yeah,
8 weeks.
yeah, so I think we'll have plenty of time. I'll restate the offer for Mr. Abbott and then correct me if there's any changes. This is a plea to count 4 of aggravated assault, that being a 1 year and or $500, is it? Can't remember if it's a 1 year. I know it's a 1 year
And or $1,000.
and or 1,000. Okay. So with a plea to count 4, the ag assault under 750A1A1A parents 1, counts 1, 2, and 3 will be dismissed. There's a Killebrew sentence agreement of sobriety court in 55th. That will take about 6 weeks to get him involved in that program. Is that your understanding, Mr. Abbott?
That's correct, Your Honor. He's got a case in 55th at this point already and a case, I believe, in 54B. And all of those, I believe the intention is to consolidate the entire bundle into a sobriety court plan.
Okay,
He's yet to be evaluated by the caseworker.
all right.
That's why.
And he hasn't been evaluated on this case either, I would assume.
Right, so we're hoping this first step will put him in a position as a misdemeanor that he can be evaluated and accepted into the program.
Perfect. All right. So may I inquire of your client of his advice of rights and the plea?
Yes,
All right. And Mr. Burleson, you along with counsel have read your advice of rights and you've signed it today. And I put it in the file. All right. You understand that if you'll be pleading guilty to there's a plea agreement, but you would be pleading guilty to count 4, which is aggravated assault. It is a 1 year, possibly punishable by 1 year and or $1,000. And then there's an agreement, a sense agreement that you go to sobriety court. If that didn't work out, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes, Your Honor.
Okay. I'm going to walk you through some rights you have today, that if you do plead guilty, you'll be waiving these rights, all right? Under this misdemeanor plea to count 4 aggravated assault, which is a 1 year, you have the following trial rights. You'd have the right to be tried by a jury. You'd have the right to be presumed innocent until proven guilty. You'd have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You'd have the right to have witnesses against you appear at trial. You'd have the right to have the court order any witnesses that you may have for your own defense. You are represented by Mr. Abbott today from the Public Defender's Office. In trial, he would be available to contest any charges and cross-examine any witnesses that may be brought by the people. Do you understand that, sir?
Yes, Your Honor.
Okay. You have the right to have the court order any witnesses in your defense to appear to trial. You have the right to remain silent during the trial. You have the right not to have that silence used against you in a court of law. And you have the right to testify at trial if you choose to testify. If your plea is accepted today, you'll give up the right that any plea was a result of any promises other than the plea agreement or any threats that are not available today. You're pleading guilty today because you are guilty. Is that right, sir?
Yes, Your Honor.
Okay, you would not have a trial today, so you wouldn't have any appeals from a trial. Do you understand that, sir?
Yes, Your Honor.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, Your Honor.
Bring your attention back to count 4. Uh, Were you, on September 23rd, 2022, at the offense location of 3201 East Saginaw, City of Lansing, Ingham County, State of Michigan, were you at 3201 East Saginaw on that date at that time on September 23rd, 2022?
Yes, Your Honor.
And in count 4, what did you do in regards to Joseph Rainier, which would make you guilty of count 4?
Your Honor, I believe the assault will be on Brian Dickerson.
Okay, so that would be as to count 3?
Yeah.
All right. So what did you do as to Brian Dickerson in count 4, which would make you responsible or guilty for aggravated assault?
I pushed him and he went into the shipwreck.
You went into the shipwreck?
Shipwreck,
Oh, the chipper.
yes.
Okay.
No, the shipwreck that was standing up.
It's a Speedway gas station, Your Honor,
Okay.
and there's a chipwreck inside the store.
Oh, so there's a chipwreck inside the speedway. And was he injured when he went inside to the chipwreck?
It scratched him up.
Okay. Mr. Wisty, was there, when it scratched it up, was there need for immediate medical attention?
No, sir, none of that.
Mr. Wisty?
I can't say that there was, Your Honor. There are photographs of it. There are some scratches.
Mr. Burleson, he was bleeding as a result of these injuries, correct?
Yeah, we were more so-
Scratches and he was bleeding?
I didn't see that it was bleeding, but yeah, but they were a little open.
And you didn't stick around long enough to see whether or not he actually did receive any treatment for those injuries.
No, I did. He left in his vehicle.
Mr. Wisty, did Mr. Rainier receive any type of medical treatment, or did Mr. Dickerson receive any type of medical treatment for the aggravated assault?
No, Your Honor.
Well, I believe,
The people would be willing to entertain, contest plea. If there was intoxication here, I would give Mr. Burleson, his attorney, a chance to confer with.
yeah, I'll give you a chance. I mean, if you want to, I'm just looking for the elements of aggravated assault. And so, if you want the opportunity to consult with Mr. Abbott and his client for a second, you can go and do that, and then we can go back on the record.
Thank you.
we're back on the record in docket 22025557.
Page 13.
Okay, thank you. And this is, my understanding is this was this was a contest, this was a guilty plea, but there are aspects that we're gonna take as a no contest plea to count one, which is the felonious assault count, in regards to the factual basis for count 4, which is the aggravated assault count. Is that correct, Mr. Wisty?
Correct. My understanding of this, Your Honor, is he'll be withdrawing the guilty plea, entering
Okay.
a no contest plea for the reason of intoxication, lack of memory. Based on the police report the court is reviewing, there should be evidence to support count 1, and thus a plea to count 3 as a lesser than that offense could be accepted by the court.
All right. Is that your understanding, Mr. Abbott?
Yes, Your Honor.
All right. So, Mr. Burleson, to go through this again, you've given up all your rights. It is your intent to plead no contest today to count 1. Is that true?
Yes, Your Honor.
All right. And the underlying theory for the no contest is intoxication, correct?
Correct.
So lack of memory.
Yes.
All right. I have case number 225190917 as the Lansing Police Department report. And I'll indicate that for count 1, which would be taken as the factual basis for count 4, that the defendant, and I've got the statement here. That the defendant was holding a Swiss Army knife with a bottle opener attachment, and Mr. Rainier was placed. And he generally believed that there was that the defendant had a knife in his hand and used it without intending to commit the crime of murder or in effect great bodily harm, and to place Mr. Rainier in fear with the dangerous weapon. That would act as a factual basis for count 4, the aggravated assault on Mr. Rainier. And it all occurred on September 23rd, 2022 at 3201 East Saginaw, City of Lansing, Ingham County, which would be in violation of count 4, which is the 75081 parents A, parents 1 aggravated assault. Any questions about the factual basis from the no contest plea, Mr. Wisty?
No, Your Honor.
Any Mr. Abbott?
No, thank you.
All right. So I'll take the no contest plea as a factual basis to count 4. We will set sentencing off over 6 weeks.
January 3rd at 1:30.
January 3rd at 1:30 p.m. And I'll leave it to the lawyer, to Mr. Wisty and Mr. Abbott. As far as doing an assessment or anything along those lines, does that have to be ordered by the court, or is that going to come out of the 55th sobriety court?
My understanding, Your Honor, is that this court has to consent. You have to consent.
Right.
To having it sent to the sobriety court in 55th. And once that consent is obtained, then they will do the assessment.
So they'll do whatever requires of their sobriety court.
Right.
All right. So yeah, so I will send to 55th District Court for sobriety court evaluation. What's that?
You took the plea here. We can't do that. So
He's got one in here, one in 54B and one in 55th.
because we take the plea here, all they can do is they can transfer the case, but it should have been pled. If that was the intent, it should have not been pled here. It should have been pled at the court where they're keeping it. That's a big issue with all the transferring and the problems, because now we have to abstract, we have to monitor. we ultimately keep jurisdiction if there's any violation.
My understanding of this is the plan here is he'll plead today. At sentencing, he'll be transferred into 55th court, and that should give 6 weeks.
If the plea should have been taken if the plea should have been taken at 55th, if that was the intent. So the plea will stay here because he pled guilty here. The case can be transferred for supervision and sentencing. But that's a whole different situation and a whole different lot of paperwork.
Okay.
So if that's the intent, traditionally you plea it in the court that you're going to. You don't plea it in the court that had jurisdiction.
Must that go around any chance?
No, she's in court in Mason. But that was the email that,
That was my understanding.
yeah, based on our email communication with the staff at 55th, that's what they wanted us to do today.
They wanted to plea here and then transfer.
That is my understanding.
That's not how we've been doing it for
But
2
it-
years.
Well, then we,
Then we'll send it to our probation department and then at sentencing, it'll be whether or not he gets transferred over.
like, you,
Because I can't schedule sentencing for a different court.
no, we've scheduled it for January 3rd. The real question is, will 55th take the case in the sobriety court coming out of here? You've told that they would. So
Yeah.
let's go on that premise and see what happens. If not, we might all be back here in sentencing, and he can always withdraw his plea, because the plea is based on a kilobrew to sobriety court. So, so that there's always the option, there's always that option to withdraw the no contest plea at 55th if sobriety court is not available. So let's go ahead and start with our January 3rd sentencing at 1:30. We'll refer to probation and with the understanding that they're supposed to talk to 55th.
Yeah.
Right, and I will inform the staff at 55th and the other prosecutors what we've done today and
All right.
the progress we've made.
So it should be, I'm gonna put should be transferred to 55th per their court. But procedure and what should happen, what'll happen are two different things. But so I'm referring you to probation. They may come and talk to you. They'll put together a sentence. I guess I'm reluctant to do an alcohol assessment at this time if I don't know what's gonna happen. But we'll keep in touch just to follow up. If that's needed, that'll get done, okay? But at this point in time, we'll refer to probation. They'll come and talk to you. They're gonna put a pre-sentence together. And then hopefully that pre-sentence will be taken over by 55th for their sobriety court. That's the hope, okay? So you'll be back here January 3rd at 1:30, okay, Mr. Burleson?
January 3rd.
All right. Anything else for the record, Mr. Wisty?
Yes, Your Honor, I believe the defendant does want to address the bond conditions.
Mr. Abbott?
I guess what my understanding is they want to request for it to be altered so that they're working to get him into an inpatient facility, so it'd be set to convert to a PR bond once he's accepted in the facility.
What he
We
said,
would have no objection to
yes.
that.
Okay, so
Request that if he's accepted into an an inpatient facility, that his bond become personal recognizance so he can be released to that facility.
Gonna
Yeah.
appear on the 7 days because they just put it listed.
he's probably being held on the other ones though, right? Yeah. So I put no objection to BR bond if released to an inpatient facility.
Yes, Your Honor, and people would want the bond to stay in place until such time. I don't know if it's automatic, 7 days. That would be the people that not happen, given we feel there's a chance that he could relapse and we want him to go right to what it is. That happening.
Yeah, they'll end up PR bonding him if he spends a long enough time in there. So, but he'll be held on the other charges, I would think. Because I can't hold him for any longer than 21 days. Unless I remand him.
You can remand them, after the 28th day.
And he's on at 10%.
Yeah, but once they plead as a misdemeanor, it automatically goes to 7-day PR.
Even on that,
Welcome to jail fund. So you can put no PR for 28 days, and that might hold them until you can get at least the screening taken care of,
I'm gonna put no PR for 28 days, just in case,
unless a bed is available.
unless bed is available.
Could we set this for review before that 20 days? Lines up here, I have to check on where it's at.
I can.
A control date just to check on it before
Sure.
January 3rd.
Well, what
So-
control data are you looking for?
Are you looking for someplace in December?
Before the 28 days, to see if he's gotten into a facility before the bond.
So, Mr. Abbott, any comment on just setting it for control date, so just we can check on it?
That's fine, Your Honor.
Yeah. So let's set it for,
I'm working on it.
all right,
December 1st.
control date of December 1st.
No, can't do that.
No,
That would be the 28th day, and he would be released that morning. You have to do it on that fun
okay,
23rd.
so December 23rd,
November 23rd.
November 23rd.
8:30.
I'll be in Minnesota.
I got nothing, Mr. Abbott. Between judicial leave and holidays,
Um,
Can somebody cover that for you? or-
Yeah, we'll find someone to
Alright.
cover that.
I'm sorry, Mr. Abbott. It's just
So November 23rd
at 8:30, I guess.
at 8:30, just to keep up, to make sure we know where the case is.
Okay.
Mr. Wisty, anything for the record?
Nothing further.
I think it's a good idea. I really do. I think it's a good idea, just so this doesn't get lost between 54B, 55th, and 54A.
I think that's correct. I
Right.
agree,
Yeah.
especially based on what she said, that this isn't gonna work anyway. So
Right,
It'd be nice to find out that either it is or it isn't.
right. We can all regroup and figure it out. But we'll do so on November 23rd as a control date, and then we'll figure out where we go from there. All right.
Thank you, Your Honor.
Pocket.
Oh, really not?
Daniel was going to get Mr. Kelt. I mean, do you want to?
Oh, we can do that. We can do Mr. Kelly.
Got it. Okay, all right, so we do-
Okay. So we're on the record in docket 22-00749 and 22-00750. People of the state of Michigan versus Michael Kelly. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Kelly.
And sir, you are Michael Kelly?
Yes, Your Honor.
All right. Mr. Wisty, this is the time set for preliminary examination on both files. How are we proceeding today?
Your Honor, we have reached resolution in both files. In 22-00749 FY, the defendant will plead guilty to an added count 3, controlled substance use, narcotic, cocaine, or ecstasy. This is contrary to MCL 333.7404, paren 2, and paren A, and paren. This is a 1 year and/or $2,000 mandatory AIDS hepatitis testing for intravenous use. That is, in exchange for that, plea counts 1 and 2 will be dismissed in that file, Your Honor.
All right. So it's plea discharge to get the amended count, which is count 3, or the added count, I should say. Added count 3, and with a plea to count 3, counts 1 and 2 will be dismissed. And that's on file 749.
Yes, Your Honor. And then file 750, same agreement essentially, plead to an added count of use in violation of 333.7404, paren 2, paren A, narcotic be cocaine. Same penalties, and in exchange for that, plea count 1 and count 2 will be dismissed.
That's a 1 year and or $2,000.
Yes. Mandatory AIDS hepatitis testing is part of the notice.
And with that, with an added count, a plea discharge to added count 3, counts 1 and 2 will be dismissed.
Correct, Your Honor.
Is that your understanding of the plea agreement, Mr. Goodrich?
Yes, Your Honor, and I would also just like to bring to the court's attention that we plan to move for immediate sentencing, as Mr. Kelly has no intention or is choosing not to do any type of probation in this matter, and we'll be asking for a jail sentence on both of these files.
Okay. Any objection to immediate sentencing in both these files, Mr. Wisty?
No, Your Honor.
All right. So we'll do one file at a time just to make sure that all the rights are covered. You understand that the use and the controlled substance is cocaine as to both files, or methamphetamine? Which one is
both are cocaine,
okay,
Your Honor.
use of cocaine?
Or narcotic.
Okay, or narcotic. All right, you understand that the possible penalty for the charge you'll be pleading to, the added count 3, is 1 year and or $2,000. Do you understand that, sir?
Yes, Your Honor.
All right. You have certain rights that you'll be giving up if you plead guilty to the charge in this case. So I'm going to cover those rights with you, all right? And I'll cover on both files, just to be sure. 749, the earlier file. So you have the right to have a trial, to be tried by jury, to be presumed innocent until proven guilty, and to have the prosecutor prove beyond reasonable doubt that you are guilty. Do you understand you have those rights, sir?
Yes, Your Honor.
And you have the right to have witnesses against you appear at trial. You have the right to have witnesses questioned by you. You're of course represented by Attorney Mr. Goodrich from the Public Defender's Office, and he would be available to contest any charges and cross-examining witnesses if we went to trial. You understand you have that right, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses that you may have to appear for trial. You have the right to remain silent during trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. Do you understand that, sir?
Yes, Your Honor.
If your plea is accepted today on 749, this file, you will give up the claim that the plea was a revolt of any promises or threats, that it was not your choice to plead guilty. Do you understand that?
Yes, I do.
And you give it, and you go understand you're giving up the right to trial, so you will have no appeal rights from that trial. Do you understand that?
I do.
All right. Is it your intent to plead guilty today and waive your rights to trial and plead guilty because you are guilty?
I am guilty, Your Honor.
Okay, then have you raised your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
I'm going to bring your attention, sir, back to November 7th, 2021, at the offense location of the 1500 block of New York, New York Street, City of Lansing, Ingham County. Were you on that block of New York in the city of Lansing on that date?
I was, Your Honor.
And in count three, why don't you tell me what you did to make you guilty of count three, which is the use of cocaine or narcotic?
I I obtained and used copious amounts of, I mean, pretty much anything I can get my hands on.
All right.
Your Honor.
Do you remember one of the substances that you used?
Yes, sir, cocaine, crack
Okay.
cocaine.
And you knew it was cocaine at the time?
I did, Your Honor.
All right. Anything in regards to the factual basis on count three of file 749 from the people?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor.
All right. So I find the factual basis to be knowing, voluntarily, and accurately made. And then we will go to immediate sentencing. After, let me take both, please, and then we'll go to immediate sentencing. So we'll go to immediate. So we're on for docket 2200750. And you understand on this file, they've added, the people have moved to add account three of use of cocaine. That means that you could be facing up to 1 year and or $2,000 in regards to this file. Do you understand that, sir?
I do, Your Honor.
Okay. And you have certain rights in this file, and we'll go through them again. Okay. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses through Mr. Goodrich, and he could contest any charges. You have the right to have the court order any witnesses that you may have in your defense. You have the right to remain silent. You have the right not to have that silence used against you. And you have right to testify at trial if you choose to testify. Do you understand all the rights you have in this file, which is 750?
I do, Your Honor.
All right. If your plea is accepted, you'll give up the right that any plea was made under duress or threat, and that it was not your choice to plead guilty. You're pleading guilty today because you are guilty.
I do.
All right. You also would not have a trial, so you would not have any appellate rights that would come at a trial. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? In regards to the added count three in this file, on or about February 16th, 2022, on North Larch Street in the city of Lansing, Ingham County. Were you on that street at that date and time in the city of Lansing?
I was, Your Honor.
And in count three, did you use some type of cocaine or narcotic on that date?
I did, Your Honor.
Go ahead and tell me again what you did to make you guilty of count three.
Crack cocaine. It was my birthday. I was having a good time. Yeah.
Okay. And then you knowingly used what on that date?
Crack cocaine.
Okay. Any statement as to the factual basis, Mr. Wisty?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made, and there's no objection to immediate sentencing. In this regard, how many days does the defendant have in regard to file 749?
Your Honor, I have that he has 41 days in both files.
Okay.
With two different stints. He had a stint back in May for 17 days, and now he's been in jail for the last 24 days.
It's 61.
Oh, wait,
It was 41 plus whatever, the 20.
What do you have?
I have 41, Your Honor.
Okay, Mr. Wisty?
No reason to doubt that, Your Honor.
So to immediate sentencing, so it's a 1 year on immediate sentencing. There'll be no probation, is my understanding. Mr. Wisty, do you have any comments on immediate sentencing in this file? Right now, he's got about 30 days in on 2 1 years.
No, I do have some comments. I have no objection to the immediate sentencing.
Okay,
There is some criminal history here, mostly out of state. It would be my guess it's tied to drug issues here, based on his statements today. I do believe some amount of jail time in addition to what is already done is appropriate. These were originally charged as much more serious matters. And I think there's a serious problem here. He doesn't want probation because he doesn't think he'd be able to do it, which I guess is admirable in some ways as he's trying to do this to other people's time, but it's actually a very sad situation because of what may come with him because of that. Given he's not in probation, I think jail is an alternative for it has.
Thank you, Mr. Wisty. Mr. Goodrich, any allocution on this case?
Yes, Your Honor. Your Honor, in speaking with Mr. Kelly, for one thing, he was sentenced on another matter that he's currently working on a sentence in jail. I think that's where some of the confusion came in on time. So he's being held on that matter. He is, while in jail, he's been working on CATs and trying to earn his GED. He informed me that he has struggled on probation in the past, and he thinks that this time being in jail is helpful to him because, you know, walking away is not an option for him there. And they've also been requiring that he takes his medication for mental health issues, which has been leaving him in a much better place. So hopefully this gap in jail will give him the break he needs and get away from drugs on a long-term basis, Your Honor. Thank you.
Thank you. Well, Mr. Kelly, what's your date of birth?
2/16/77.
Okay, so you're not a kid, you know.
No, sir.
So I give you credit for understanding that probation's not for everybody, all right? And that maybe your time is best spent not under the angst and stress of probation, all right? But this is a pretty good deal you're getting. That's 10-year felonies out of the legislature for possession of narcotics, and they're felonies, and you're going down to a 1 year, which I think is there's no assaultive crime here. There's no property damage that I can see, you know, associated with this. This is just the possession that was pled down to a use. And it looks like you're making active time in your use in jail right now. And so on some level, I'm gonna reward you today, but I'm gonna do it with the understanding that you understand the sentence, okay? I'm gonna sentence you to 180 days in jail with 41 days served, okay? With that time, you are the best to understand what you can do with that time. And I think you're doing really good things with it, and I continue to do good things with it, okay? So I'm gonna sentence to 180 days in jail with credit for 41 days time served. I'm gonna waive all fines and costs. I don't think I can waive the crime victims' rights fee. Right. So I'll have $75 crime victims' rights fee that I will close administratively. Is that ACMC? Okay. I'm learning the codes. And then, so sentence 180 days on file 49 and on file 50, sentence 180 days credit for 41 days served. I don't think I can waive the $75 fee on that, but I will administratively close the file so that doesn't present itself. So you got about 5 months left, okay? So do the best with them you can, all right? All right, thank you. That's all for the record. Both of these files, 22-00749 and 750. Anything else, Mr. Wisty?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor.
All right, thank you. Good
Thank
luck
you,
to you,
Your
sir. Okay. Zero three, people of the state of Michigan versus Eric and Knickerbocker. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Knickerbocker.
And sir, you are Eric Knickerbocker? Sir. Okay, this is the time set for preliminary examination on the matter. Mr. Wisty, how are we proceeding today?
We will be proceeding with the hearing, Your Honor.
All right. Any preliminary matters to come to the court's attention before we get started, Mr. Wisty?
No, Your Honor.
Anything, Mr. Goodrich?
No, I believe this is a one witness
That is correct.
All right, all right. With that understanding, Mr. Wisty, you can call your first witness.
Damon Pulver. I may be excused.
You may.
Thank you, Your Honor.
Your Officer Pulver.
Yes, sir.
Stay right here. Please state your name and spell your last name for the record.
Damon Pulver, DAMON PULVER.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, thank you. You sit right there and project for the recording.
Yes, sir.
Mr. Wisty, you may proceed.
Thank you, Your Honor. Could you state your name for the record one more time?
Officer Damon Pulver.
And you're an officer, where you've been officer from?
I am an officer of the Lansing Police Department.
How long have you been in that position?
I've been a police officer for over 2 years.
Were you working on October 18th, 2022?
I was.
When you were working, did you come in contact with the man by the name of Eric Lee Knickerbocker?
I did.
How did you come in contact with him?
I came into contact with him when I conducted a traffic stop.
What was the reason for the traffic stop?
There were multiple reasons for the traffic stop. I stopped him for failing to stop and leaving a private drive, for speeding, and also for pulling into the second lane instead of the first available lane.
When he stopped his vehicle for you, correct?
He did stop.
When he stopped the vehicle, where did he stop the vehicle at?
He stopped on Orchard Street with the cross street of Pennsylvania.
Is that in Lansing?
That is.
Is that in County of Ingham, Michigan?
It is.
Do you see Mr. Knickerbocker here today?
I do.
Did you point him out and identify something he's wearing?
He's sitting right over there with the Reebok zip-up sweatshirt.
May the record reflect the witnesses identified the defendant?
Without objection?
No objection.
Without objection, the witnesses identified the defendant.
After you stopped Mr. Knickerbocker, what happened next?
He was unable to provide proof of insurance, and when I checked his vehicle through our system, it came back with no insurance on it.
Did you
So-
come to make a decision because it had no insurance?
Yes,
What was that decision?
to tow the vehicle.
After you decided to tow the vehicle, what did you do next?
I had Eric step out of the vehicle and told him to just go to the back of the car. And he told me that there was a firearm in the vehicle.
Tell you anything else about the firearm?
He said that it was loaded and that he did not have a CPO.
Did you see the firearm?
Yes, I did.
What happened with the firearm?
I recovered it and tagged it in evidence.
And where did you recover the firearm from?
The firearm was just behind the center console, so as if you just, when you're driving, you would just put it right in the back seat there.
And that's inside the vehicle.
It's inside the vehicle.
Was anybody else in the vehicle?
There was no other occupants of the vehicle.
No further questions, Your Honor.
Cross-examination, Mr. Goodrich.
Thank you, Your Honor. Officer, where was it when you first saw Mr. Knickerbocker's vehicle?
I saw him pulling out of the Beverly apartment complex.
And is that roughly in the neighborhood of Hunter Park there?
Yep, that's right across the street.
Okay. And what time of day are we talking about here?
This is at 3 o'clock in the morning,
All right,
around
so
3:30.
is it fair to say that probably not a lot of traffic on the roads at that point?
There's less traffic, but that area, there's a bunch of foot traffic all hours of the night and people driving up and down, so it's not necessarily no traffic, but there is a reduced amount, yes, at that time of day.
Okay, when Mr. Knickerbocker did he pull onto Kalamazoo then from there?
Yes.
And when he did that, did he strike any vehicles or anything along those lines, or nearly hit somebody, or?
There was no striking of any vehicles. There was another vehicle that was actually driving past the apartment complex at that time. But no, there wasn't, he didn't almost hit anybody or any pedestrians.
So this was essentially kind of a what you would consider kind of a rolling stop when he was leaving this apartment complex?
Yes.
And how often is it that you ticket people for essentially rolling stops out of private drives like that?
I wouldn't know how often I issue people citations for that.
Do you recall doing it anytime recently?
I have court later this week for somebody that I gave a citation to just on the street for that same exact things.
Okay. And then you testified that Mr. Knickerbocker was speeding, is that correct?
Yes.
Did you ever like get a radar speed on him at all?
No, I didn't have a radar speed or anything. I was just using basic speed law for that site or that reason for the stop.
Well, could you explain what basic speed law is?
Basically meaning that I could tell he was going over the speed limit just by the speed that I can see him driving at and me trying to catch up to his vehicle. I didn't have any time or enough space to conduct like an actual pacing of the vehicle for a radar. But I could tell just by visually looking at the vehicle and him driving around and me being in that area very frequently that he was going over 25 miles an hour.
Okay, so it's really came down to more of your estimate because of the
Yes.
short period.
Yes.
And then I believe I saw in your report, you were also concerned about foot traffic on Michigan.
Yes.
Did he ever get to Michigan Avenue?
Yeah, past the Michigan Avenue.
All right. And I guess how much foot traffic are we were concerned about at 3:30 in the morning? Because I mean, the bars would be closed at that point, correct?
Yep, the bars would be closed at that point, but I mean, Sparrow Hospital, all hours of the day. I mean, you talk to any Sparrow nurse, they'll tell you that that place is always packed and there's always people getting discharged and everything. There's plenty of kind of bus stops that are right there that people are walking back and forth on that are across the street from Sparrow. So I don't know specifically how much foot traffic there was that night, but there is frequently foot traffic in that area.
Okay, so you didn't see any, but you were, based on prior experience, you're guessing that there would be some essentially?
Yes.
When you pulled over Mr. Knickerbocker, did he comply fully with what you asked of him?
Yes, I mean, he wasn't able to provide insurance or registration, but he did have his driver's license.
That was because he didn't have any, correct?
Correct.
He complied to the best of his abilities based on what he had.
Initially, yeah.
And when you found the gun in the back seat, was it in a holster?
It wasn't a holster.
Okay, so it was not in a position where it could have been fired anytime, any easily, essentially, from a person driving a vehicle?
I mean, it wasn't like a very secure. It wasn't secure, so it was loaded and it was within arm's reach of him. I mean, it was still in a holster, like you said, but it's not. It could have been easily used for pretty quickly.
Your Honor, I have no further questions at this time.
Mr. Whitney, any redirect?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Mr. Goodrich?
Yes, Your Honor.
Okay, without objection, the witness is excused. You can leave
Thank you,
leave
Your
the
Honor.
witness chair. Mr. Whitney, any further proofs?
No, Your Honor.
Do the people rest?
Yes, Your Honor.
Mr. Goodrich, any proofs for the defense today?
No, Your Honor.
Motion for bind over, Mr. Whitney?
Thank you, Your Honor. The people would move to bind over on count one, carrying a concealed weapon. The elements are that the defendant carried a weapon inside a vehicle with knowledge that carried a pistol inside a vehicle with knowledge that it was a pistol. We heard testimony today from Officer Pulver that he pulled the defendant over. He found a firearm. The defendant said it was the firearm. All elements are met, Your Honor, and people would move for bind over.
Mr. Goodrich?
Your Honor, we would just leave the matter to the court's discretion at this point.
All right. This is a probable cause hearing, which is preliminary examination hearing, with probable cause being the standard. Probable cause being the second lowest standard. Circuit court requires guilt beyond a reasonable doubt, which is a higher standard. So this court finds that on October 18, 2022, as testified to by the officer, Mr. Officer Pulver, that on Pennsylvania and Orchard Street in the city of Lansing, Ingham County, the defendant did carry a dangerous weapon, a pistol. It's a loaded pistol. It was behind him, but reachable. And he did it knowingly because he's the one who told the officer that there's a pistol in the back seat. That was prior to the inventory search that was taking place because the car was going to be towed for no registration or life or insurance purposes. That being a silver Escalade. I find that at probable cause level, Officer Pulver has indicated the elements of the crime of carrying a concealed weapon, in this case in a motor vehicle, on the date and time in question, and therefore the court will bind over on CCW in a motor vehicle to circuit court. So your time in district court is over. Any other questions you have for circuit court or dates there, you should keep in contact with your attorney, Mr. Goodrich, okay? All right, so the case is bound over to circuit court. Probable cause is met by the testimony of the witness. Anything further from the people, Mr. Wisty?
Nothing from the people. Your
Anything,
Honor.
Mr. Goodrich?
No, Your Honor.
All right, thank you. All right, that's all for this case in district court. Your next stop, circuit court, sir, okay? Thanks.